release order. That is why I want file mail for release of the amount.
Oh, you can.
My lord, on 7, day after tomorrow. Okay.
Right, please. My lord, item number 19, my lord, I am mentioning, my lord, motion matter. My lord, some urgent personal difficulty has arisen today, my lord. So this
Issue number 19.
19, my lord, motion, my lord. This may be adjourned for today, my lord. And my lord, it may be taken up on 9, my lord, last day on 9.
9th, we are not listing much matter because
on-
of some reasons. Maybe on 8 only.
8, my lord.
8 can be.
Yes.
Adjournment prayer to D2 or 8.
Please, Lord. I beg to mention for listing one FAO tomorrow, Lordship. This FAO is filed along with an IA filed under Order 39, Rule 1 and 2, seeking temporary injunction. The petitioner appellant is agreement for sale holder in respect of property.
Just a second, Mr. Ali. Question is that item number, court number 9. You have to make a mention before court number 9, senior court. Immediately go and mention it.
May please, Your Lordship. With regard to item number 43, Your Lordship, can it be after a week?
43.
43, Your Lordship.
There was here the I2 I's are also there.
Yes, Your Lordship.
One is for most probably for condonation.
Yes, Your Lordship. Let it be after a week, Your Lordship.
The prayer made by Learned the matter of state after a week as on a date to be by the registry.
Much obliged, Your Lordship.
My lord, with regard to item number 2, my lord, some personal difficulties today, my lord. It may come on 8, my lord.
It's a TRP only. Why on 8?
My lord, actually my senior, my lord, he fractured his leg, my lord.
No, it's okay. Why on 8?
My
Little
lord,
beyond
my lord,
after
today-
Bihu will do.
No, today my lord, his
No,
fracture.
I'm not on that. After Bihu will do. That's what I'm asking.
Lord,
Because if he has fracture,
Lord, the fracture today,
going
his
to
fracture
fix
is,
the date.
today his fracture will be open, my lord. By 8, my lord, he will be all right. My lord. Can we 8?
8. At the request made by 8.
May I please, Lordship?
I'll
Item number 20, Lordship. I have
20.
20. I have instruction from my client. They want to withdraw this petition. Lord.
You want to withdraw it?
Yes, Lord.
You are Mr. D. Kalita.
Yes.
Part Mr. D. Kalita will announce the petition and the instructions of his client. He wants to withdraw the same. Prayer matter is accordingly disposed.
May I please, Your Lordship? Like to mention for adjournment of item number 31, Lord. We would like to place some new additional grounds.
31.
31.
So for additional ground, you're going to file an additional affidavit.
Yes.
You are Mr.
PD Bhuya.
Mr. PTP, the learned.
My Lord,
Yes.
not additional affidavit, additional ground, my Lord. By additional, my Lord, appeal member.
By additional appeal member.
Appeal member.
Mr. PTP, the learned counsel for the
Appellant.
appellant, and it is paid for an adjournment stating that they are going to take some new grounds through an additional memo. Prayer out. Leave the matter. How many weeks you need?
4 weeks, my Lord.
4 weeks. List the matter accordingly as an indicated by
Additional appeal member by inserting new ground, my Lord. Additional ground. Otherwise, my Lord,
that's what I'm asking.
Yes, ma'am.
I have already dictated additional ground you want to take.
Yes.
Through new
Yes,
additional appeal member.
May I please, Your Lordship?
4 weeks, right?
Lordship, I will mention for adjournment, my senior is on leave, Mr. DCC Fuka,
Which item you are saying?
item number 32.
Item number 32. Your senior is in?
Is on leave.
On leave means he is not available. He is
Sorry.
not available today.
Yes.
Leave note yes. Leave note yes. Order. You want after a week? After a week you
Bihu.
want? Huh?
After Bihu.
After Bihu vacation? After Bihu vacation as an date to fix by the ministry. Yes, Mr.
My pleasure.
The court number 9 will not take up any motion matter. So, you are directed
No, no,
mention this
motion
matter.
matter may come before this court. I'm not on that. You make a just mention so that matter may be listed. That's what I'm asking.
That court was asked me to mention here.
No, I can. Senior court কোন আছে ইয়াতে? Rule book আছে। তেওঁতো কৰিব লাগে।
So this FAO is filed along with an injunction application.
Huh.
Lordship, the petitioner appellant is agreement for sale holder in respect of suit
Okay.
property.
You're going to FAO is already filed or
No,
not yet?
Newly filed, Lord.
Newly filed.
Newly filed. Along with an application under order 39
You
rule
will
1 and 2.
get it listed tomorrow.
Tomorrow, Lordship. Matter is very urgent, Lordship. The owner already obtained NOC and they are going to execute sale deed in respect of, in favor of other third person. So otherwise case will become infructuous.
Okay.
Hello.
Make please, your Lordship. Lordship, I beg to mention CRP 74 of 24 for listing, Lordship,
74, 24.
of 24, Lordship, for listing.
Let it be on 8.
Obliged, Lordship.
Please, your Lordship.
Yes.
Subsequent second application, Lordship.
Hmm.
Lordship, earlier petition was rejected by Lordship by order dated 15/12/2025, which is on page number 31, Lordship. Lordship, earlier we have taken up the ground that the present petitioner was kept in custody for more than 24 hours. And that was in direct violation of the Article 22, Lordship, wherein in the last petition, the learned prosecution side has submitted. May I come to the relevant para of page number 34, para number 9. Lordship has found it.
Yes.
Lordship, on para number 9, Mr. Sharma further submit that it is not a case that the present petitioner was apprehended or arrested on 23/11/2025, but it is a case wherein after getting the information the petitioner was interrogated and a preliminary inquiry was made by registered GD entry, and after preliminary inquiry only the FIR was registered on 24/11/2025 and by complying the notice so and so. Here the prosecution side has submitted that neither the petitioner was apprehended nor he was arrested, means he was not taken into custody. But Lordship, if Lordship comes to the FIR, we have found out in the FIR itself, the IO has admitted that he was taken into, but he was apprehended. May I come to the relevant para, Lordship?
No, anyway, this is in your new ground. You want to say that this is your new ground.
But-
But most probably that has already been discussed in detail.
It-
Why your rejection petition was rejected.
It was,
Earlier bail application, because that is the main ground most probably you have taken because of 24 hours. That was the
yes,
ground.
yes, that was the ground.
So in that regard too, I have already, observed every aspects of the case. Anyway, your petitioner is in custody since when?
It has been 42 days. It has been 42
What
days.
cases under which section?
There are
The number
sections
plate
will
and
be
all,
60
every
days,
case,
60 days of
It's a
it.
very big case of cheating and all. I
Yes,
can
yes.
remember. Yes.
Materials are there in the, it was there in the case diary. But only that because the prosecution has submitted that he was neither apprehended nor arrested, but he was apprehended in that phase
As
of
we
the,
want to say, in the FIR itself, it is.
it is written.
Okay, we are listing just, we're calling for the case diary. If any development is there, see the call corridor. When it can be listed?
Lordship, after view vacation.
After week vacation. After week vacation, we'll do, because 2-3
It is
days, I don't
40
know.
days, Lordship. And violation is also there. I can, Lordship, violation is also there, Lordship.
Only 4 days left.
On 9th, maybe,
Night, we are not going to list much matter
because
we have some issues as a whole.
Let it be on 19th, on the very reopening.
We'll do on 19th,
19th.
at the very reopening day,
Yes.
19th. Okay,
Obliged.
19th. Okay, we're listing it on 19th.
Obliged.
Morning, Your Lordship.
Yes. Is a transfer petition.
Morning, Your Lordship. This is a transfer petition.
Huh.
This transfer petition is filed by the respondent of the matrimonial proceeding in civil in family court. There's a case by the
Presently, it is pending before which court?
family court, ma'am.
Family court, Kamrup Metro.
Kamrup Metro, ma'am.
So you want to get it transferred from
From Kamrup to Goalpara, ma'am.
Goalpara.
Yes, ma'am. The petitioner, Dorsana Bora, she is a working lady in government BEd's college in Goalpara, and she has a child. She has the full custody of her child. He is a premature baby. He has just turned 2 years this November 2025. So it's practically very impossible for her to travel to Guwahati on every day. And also, ma'am, this baby who is a premature, it is advised by the doctor that he shouldn't travel very frequently. And I've also annexed all the medical documents suggesting that he has been, he was born
Okay,
on
now,
27
this
weeks.
is at the motion stage. We are going to issue notice. And any other prayer from your side?
Ma'am, until and unless this case goes on in this court, all the proceedings may be put to stay in the family court, because if every thing goes on with the family court, if there are proceedings, then this transfer petition would be of no use, ma'am.
No, but the question, no use. Why are you saying no use? It will be cases there everywhere. It will be disposed of. Maybe in Goalpara, maybe here also. So the question is then, for each and every day your presence is required. I don't think so, because if suppose family court, yes, I can understand family court. There are some restrictions in
Yep.
appearing the advocates. But the question is that if there's such petition under section 10 or something, I just forgot. So it can be filed, and if it is allowed by the court, then the advocate can represent. Now, what is the stage of the case at present?
Ma'am, it just for the first hearing.
For the first,
First hearing would happen on 7th.
it listed on 7th
Yes, ma'am.
this month.
This month.
So her presence is required here.
Yes, ma'am.
You are Mr.
My name is Arnav Kanikar, ma'am.
Or Mr. A. Kanikar, Dilani Council. This is an petition under section 24 CPC for transfer of FC civil case number 1236 2025 the court of Planet Principal Judge Family Court number 3 Kamrup Guwahati to the court of Planet District and Session Judge Goalpara. Issue notice to the respondent to speed post to speed post and as a process. Also call for this scan copy of the TCR. Next one, further considering this submission made by Landing Council for the petitioner, date further proceeding in FC civil case number 1236/25. We stay till next date of the state. This matter accordingly weeks as an edit to fix by
Highly obliged, Your Honor.
But please, Your Lordship, this is a transfer petition of a divorce proceeding by the wife from family court Nalwari to family court Barpeta. Lordship, she is a lady residing in a rural area of Barpeta district, Bishnupur, village Bishnupur. And she has already filed another divorce petition before Family Court Barpeta and 125 proceeding before Family Court Barpeta. Her husband has filed the proceeding at Nalbari. We have annexed the two
Which was
orders of the Nalbari court.
earlier application was filed by her or by
Husband,
husband? Huh?
Husband,
By her husband.
by husband. Subsequently, she has filed the petition, divorce petition on her grounds, own grounds, with alimony, etc. And also 125 proceeding, Lordship.
So why didn't she didn't make
Because
any prayer in the set state petition for if the alimony is concerned?
The grounds mentioned in this petition at Nalbari are totally false. 20 grounds. She has filed on her own ground. Lordship.
After
So
filing
once
a
it has been
one,
transferred, both the cases may be tried analogously, no problem on that part, Lordship. And practically, she has find it difficult to coming to Nalbari, Lordship.
no, but the question is that the one petition was filed by her husband seeking divorce,
Yes, Lordship.
another petition filed by her seeking divorce, and
Then maybe compromised or maybe transferred, Lordship, once it has been transferred. And she has filed another petition under 125 also, Lordship, at Barpeta. Barpeta is 10 kilometers away from her residence, Lordship. Nalbari is 80 kilometers away. No direct communication is available at Nalbari. Lordship may go through the page 31, Lordship. Because Family Court Nalbari, it is one date she has appeared. For the next date, she has not appeared. Case gone ex parte and now fixed for ex parte hearing, Lordship. Her father's parents are ailing. She has no other siblings to visit every date before the Family Court Nalbari, Lord. And in the Family Court, lawyers are not allowed. Even she cannot take steps through lawyers. We have annexed the medical documents of her parents also, Lordship.
so till date for vacation of the ex parte order is not been filed.
No, I have not appeared only one date. After
No,
receiving
appeared in
summons.
one date.
But-
It is there only in 30.
No, next date is Lordship on 20th January, Lordship. As paid 32, Lordship.
Yes, I have seen.
And we have filed 125 proceeding that is pending in Family Court, Lordship, Barpeta.
For Mr. S.K. Putra, Delani Council for the petition. This is an application same on section 24 CPC praying for transfer of MS bracket of D, case number 238 of the 2025 from the Court of Learned Principal Just Family Court Barpeta to the Court of Learned Principal Just Family Court. Oh no, sorry, Nalbari to the Learned Principal Just Family Court Barpeta. Issue notice to the respondent through speed post and as usual process. Also call for the scan copy of
We will also pray for stay
ECR
of the
of-
further proceeding, Lordship.
ECR of both. No. Your case number is
My case number is Lordship. This
Barpeta case number.
Barpeta case just FC 428 public 25
FC Civil 428.
public 25 and Nalbari case is MSD 238.
Put the TCR of put the case number of MSD bracket of D case number 238 of 2025 and pending in the court of Principal Judge Nalbari and FC Civil case number 428 of 2025 pending before the court of Principal Judge Family Court. Further, next matter, considering the further, it is further submitted by Mr. Putter that the present the respondent had filed the MSD 238 of 2025 seeking divorce, which is pending before the Principal Judge Nalbari, and the present petitioner has also filed another divorce petition, which is pending before the court of Principal Judge Family Court, Barpeta. He further submitted that she also filed and maintenance, and he also filed a petition
144
maintenance.
BNS.
under which
144 BNS.
144 BNS. seeking maintenance, which is also pending before the court of family court Barpeta. Accordingly, he submits that a petitioner being residing in a very remote area of Barpeta, is not in a position to appear before the learned principal judge family court Nalbari on each and every date, and for which the present petition has been filed. Further, he submitted that due to illness of her parents, she could not appear on one date before the learned principal judge family court Nalbari, for which case is already for which the order has already been passed for proceeding of the case ex parte against her. Next para, considering the entire submission made by Mr. Potter, the counsel for the petitioner, let the further proceeding in MCD Asana, the Asana number 2, be state till next date of the state. Please the matter accordingly after 4 weeks as on a date to be fixed by the administrator.
Wait, please, Your Honor. This petitioner is the wife. They solemnized their marriage on 14/12/2021. After about 6 months, my lord, this respondent husband started torturing her. Even demanded rupees 5 lakhs from this wife, my lord, this petitioner. And even one time, my lord, after several, my lord, physical torture, one time she was, my lord, placed with a pillow over her mouth to kill her. By this way, my lord, and what happened? She was, my lord, given a separate room. The husband, this respondent, he lives in another room, my lord, with his mother and others. So this petitioner had to leave this matrimonial home on, my lord, 14/7/2023. After coming from this, my lord, matrimonial home, she filed one DV case, my lord, which is at page, my lord, 12, Annexure 1. This CRDV case was, my lord, after hearing both the sides, my lord, the order relevant portion, if your lordship kindly give what relief was given to this petitioner at page, my lord, page, my lord, yes, 39, page 39. It starts from 38, my lord. In view of the above discussions and findings, it is hereby ordered that, number 1, the respondent number 1 is hereby prohibited from committing any further acts of domestic violence upon the aggrieved and attempting to communicate in any form whatsoever with the aggrieved person, including personal, oral, or written, or electronic, or telephonic contact. Number 2, respondent number 1 is directed to secure her same level of alternative accommodation or to pay her rent if she acquires a rent house. Thirdly, respondent number 1 is directed to make payment of rupees 3,000 per month. Number 4, respondent number 1 is directed to make a payment of rupees 8,000, say compensation. But this, my lord, order has not yet been complied, and he has filed one, my lord, divorce case. Divorce case in, my lord, North Salmara, Obhayapuri, which is about 30 kilometers from the residence of the petitioner. Now, what happened, my lord? After coming from the residence of the, my lord, matrimonial home, she, my lord, engaged herself in a private school, earning only rupees 3,000. So if he has to leave this, my lord, from to Obhayapuri, she will lose this job also. So, dear my lord, I pray that from this court of North Salmara, Obhayapuri, to, my lord, the court of, my lord, additional district judge, Bilasipara, Dhubri. This is a simple prayer, my lord. Because this husband has not complied the order of the domestic violence passed by the honorable court, my lord. So till then, my lord, I humbly pray this, my lord, the case that is TS divorce number 23 of 2025, which is filed under section 13(1) and I-1B of the Hindu Marriage, may kindly be stayed. The torture, in fact, from this Milord case of domestic violence, the order, just I have Milord read over before your lordship, it's clear that there was domestic violence, and he was directed to pay per month. That is also not given. No accommodation is given to her. She again had to come back and staying with her mother, only mother. And my lord, she is earning only rupees 3,000 in a private school. Private school, if she goes near my lord to North Salmara, she will have to lose the job. So therefore, my humble prayer before lordship to stay this divorce case pending in the court of North Salmara, in the additional district judge North Salmara, so that my lord, let them both the party appear and
Mr. R. Goswami did an
R. Goswami.
and also supposed with an application section 24 of the CPC train for transfer TS capital T 23 of 2025 pending before the court of additional district judge North Salmara of Bayapuri to the court of additional district judge Bilasipara to issue the response through speed post and SBB process, and also for this kind of copy of PCR of TSD 23 of the next further considering the submission made by Learned Counsel Mr. Goswami that the further proceeding in TSD 23 of the 2025 pending for the court of Learned National
District and session judge
district
North Salmara.
pictures not Salmara, the state till next date of the state. The estimate accordingly after 4 weeks and then
Obliged, my lord.
yes.
May I have your lordship? In this case, lordship, paternal lordship, petitioner filed title suit. And in this case, lordship, we issues frame, and the case was fixed for lordship evidence lordship. But the petitioner could not file the evidence lordship on the fixed date lordship, but the case counsel submitted his application. Thereafter, lordship, when matter was fixed lordship, she could not communicate with the council, and but council have also not taken any steps. On the same date, lordship, the case was dismissed for non-prosecution. But this was not informed by the council to the petitioner. Petitioner is lordship lady 78 years old lady, lord. And then lordship some delays was occurred, but petitioner filed subsequently a restitution petition along with condonation petition. This was dismissed by the High Court lordship.
Restoration is also dismissed.
Dismissed. Condonation was dismissed. Consequently, restitution also dismissed.
Yes.
Against this lordship, I have filed it.
So delay was how many days?
Delay was 217 days.
Quite a big delay. I mean,
but-
long delay, na?
Because lordship,
Where is the
late
order
was-
you have annexed?
lordship,
Order you have annexed?
I have annexed. Order is lordship, page 49, lordship. Petitioner lordship, along with this condonation petition, submitted the some medical documents lordship. He was lordship 78 years old lady, lord. And this was not properly considered, lord.
You should notice here now.
Lord.
But Mr. A. which had done it. This is an application under Article 7 Constitution of Federal Section 115 with 151 CPC against the impugned order dated 16/9/2025 by Learned Civil Justice Practice Senior Division Number 1, Kachar Silchar, in Ms. case number 240/2025, in connection with title suit number 12/2022, rejecting the petition for condonation of dealing in filing the petition for restoration of title suit, which was dismissed for non-prosecution by order dated 5/11. Issue notice to all the respondents to speed post and also for the DCR. Let the matter be. You text it through
Sure.
nowadays through speed post
Right, wait,
and also as usual process.
Sure.
List the matter accordingly after 4 weeks as on a date. Text it.
May I please go this? Lordship, petitioner, your lordship, got married with respondent, your lordship, in the year 1994, your lordship.
What you have said?
Petitioner got married with respondent in the year 1994, but due to some matrimonial issues, she started living separately along with her minor daughter, your lordship, from 1997, your lordship, in her parental household.
Got married on 1994,
94.
separated on 1997.
97, along with her minor daughter. Subsequently, she filed an claiming maintenance. She filed 125 CRPC claiming maintenance. And it was subsequently enhanced, your lordship, on 24 to 2022, up to 7,000, your lordship. I have annexed this order at page 21, your lordship. Kindly tell.
It is annexed up to 7,000.
7,000. That order has been challenged by the respondent, your lordship, before this honorable court, your lordship, by filing a criminal revision petition.
Achha.
In this revision petition, your lordship, he has stated that he had already given divorce to the petitioner. Your lordship. But and also he had and also stated in paragraph number 7, your lordship, that upon receipt of some amount, your lordship, petitioner has relinquished her right of maintenance. Your lordship. That revision petition was ultimately dismissed, your lordship, affirming the order passed by the family court of 7,000. Thereafter, your lordship, petitioner submitted an application before the family court claiming her arrear amount as well as the monthly maintenance, your lordship. Against that, your lordship, he has filed this FC civil case 448/2025, your lordship, for dissolution of marriage, your lordship, on the very fictitious and fabricated grounds, your lordship. In the earlier petition before this honorable court, he has claimed that he has already given her divorce, your lordship. And in this petition, your lordship, kindly peruse the paragraph number 7.
Your petition.
No, your lordship, petition filed by the respondent.
Page number.
Page number 77. And also, your lordship, he has concealed the fact that he has already got second marriage without obtaining. He is a government servant without obtaining permission from the government, your lordship. He has got second marriage, your lordship. That point also challenged before this honorable court in earlier criminal revision petition by the petitioner. Petitioner 7, paragraph 7 may kindly cover. That since 1997 till date, the respondent did not come to the matrimonial life of the plaintiff. That is, in spite of repeated request of the plaintiff, and without living together, the plaintiff is suffering very badly in his old age, as he is suffering from various ailments which amounts to gross negligence and fault of the respondent, and it amounts to mental cruelty, mental shock, and agony, etc. The plaintiff was always willing to ready and take her respondent, but the respondent did not pay response to the plaintiff. The plaintiff has waited to the respondent for performing matrimonial life by expecting the bright future, but due to gross negligence and fault on the part of the respondent, it is clear that the respondent is very much disobedient to her husband plaintiff. According to the Islamic rules and regulation, if a wife becomes disobedient and does not comply with the husband, does not come forward for performing the matrimonial life, it amounts to mental cruelty and neglect. Lordship, may kindly peruse the revision petition which he has filed before this honorable court. Page 25. This petition filed by the respondent, your lordship, against the order passed by the paragraph number 2, may I read, your lordship? Page 25. The petitioner begs to state that the that petitioner got married with respondent number what in the year 1994, and out of their wedlock, one daughter was born. Thereafter, due to some matrimonial dispute between the parties, they started living separately and got divorced in the year 1990. So also he has stated in paragraph 7 also, Your Lordship, that he has already given divorce to the petitioner, Your Lordship, which is completely false statement, Your Lordship. And also he has annexed and fabricated document before this honorable court, Your Lordship, which was in dispute, Your Lordship. So
now what is the stage of that divorce petition filed by him?
it is on the service stage, Your Lordship.
So what is your prayer here?
Yes, Your Lordship.
Your prayer here?
I'm praying, Your Lordship. At this stage, notice may be issued until the,
No,
Your
no.
Lordship.
You have filed this petition against which order or what? That
Just not to comply the order or the maintenance, Your Lordship. He is lingering the process, Your Lordship. First, he has filed a modification of this
No, I can
family court
understand,
order.
but
Your
what is your prayer here in this case?
In this case, Your Lordship, I'm praying for issuance at this stage, issuance of notice and
no, issuance will be okay.
and
Otherwise, what is your prayer?
and the case, Your Lordship, FC civil court is to be stayed, Your Lordship, till the retirement.
No, status question is different. It is the interim prayer. I'm asking what is your prayer here in this case?
In this,
These are the interim. I can understand. What is your prayer? Why you have filed this petition?
I'm for the dissolution of this family court case,
Huh?
Your Lordship. For quashment of this case, Your Lordship. FC case.
What, man?
For quashing the FC case, which has been filed on false ground, Your Lordship, by the respondent, Your Lordship. Lordship, kindly peruse my prayer.
You are not your petition. Your revision petition is not against any order.
No, revision petition has been filed by the not against any, this revision petition has not been filed against any order.
There it is in evidence stage.
It is filed.
Order has been passed now. Now why you have come here?
It is
Why you have come here?
for quashing the proceeding which is pending, Your Lordship, before the family court, Your Lordship.
Where is the prayer for quashing the proceeding? Where is the prayer?
Prayer, Your Lordship, page 12, Your Lordship.
No prayer.
Page 13, Your Lordship. Pass an order to set aside and quash the proceeding of the civil case pending in the court of principal judge family court, and pass an order to direct the respondent to pay monthly maintenance at rupees 7,000 per month, as well as the arrear amount of the petition, which just not to pay the month.
Why 7,000? Question of 7,000 will come here now.
He is not paying, Your Lordship.
That will come another case only.
Just not to pay this amount, Your
No,
Lordship.
you have come against that. I mean divorce only.
Yes, Your Lordship.
So why? What is question of 7,000 here? How 7,000 will come here?
Then I'm not pressing this debt.
Huh?
This prayer. This prayer.
The petition is not maintainable. Simply issue the notice at this stage. You see what is your defect in your petition, and then you come. The petition is defective. You can come. This petitioner, he is not obeying this. Not paying any amount to you. Rather, he is paying. That may be one of the ground for against that order.
Yes, Your Lordship. But just not to pay, Your Lordship, he has filed the dissolution of marriage petition, Your Lordship, on completely on false and fabricated grounds, Your Lordship.
But in dissolution of marriage, you have not filed any. Written statement.
No.
You have not filed it.
Not
Then what is the issue? I mean, why you have come here? If suppose there is a question of any, suppose it is not maintainable, suppose whatever, you can raise the issue there itself. In the family court itself, that is a question is not maintainable. It may not be maintainable, whatever. And in the WS also, you can take these issues, preliminary issue can be framed and that can be decided. Why have come here?
At this day, I'm
not follow anything.
I'm praying for issuance of notice.
Notice is question is there's nothing is in petition here. There's no anything is nothing is there. I mean, there's nothing in the record. So why you have come? There has to be some reason you are coming before. He may file a petition. Vexatious petition may be there once you have submitted that once he had taken the plea of divorce, that he had already been divorced. Then again subsequently we just saw false some statement, he made another case, and then a revision petition, and then again the divorce petition.
He is just lingering,
there are some.
Your Lordship, just not to pay the
maintenance. What will be the here? Now, see, you see the petition, you just discuss, think twice. I'm just fixing it another date. This week only. On 8, I'm fixing just. It may not be 8 on.
After Bihu, Your Lordship.
After Bihu, I'm just fixing.
Yes.
I won't pass any order. You are just fixing it. You just see the order. If anything can be prayed before the learned principal judge, before there only,
Yes.
you can raise those issues, isn't it? Your case is that there is a false case has been filed, seeking divorce,
Yes.
taking 2-3 similar grounds, only to avoid himself from paying your maintenance,
Maintenance.
that which has already been passed, enhancing the up to 7,000. These are the issues, and it is an admitted fact that you are the wife
Yes.
and you have also a minor daughter. So that is there only. So seeking maintenance, maybe very correctly you have sought for. So I'm just fixing it. After Bihu,
After
28th January will.
Yes.
Okay. This the matter on 20. You just think it up, think over it, and just
apply.
May I please?
yes.
In this case, suit has been pending. I am the principal defendant and respondents are the plaintiffs. They file a suit for their right title interest and cancellation of my sale deed. I am also the registered owner of the in respect of the suit land. I have purchased the same in the year 2008. Subsequently, name has been mutated in my land and land has been bifurcated by creating a separate Dakpatta. I have been possessing the same. In this case, Lordship, after filing of my WS at an initial stage, after framing of the issue, I have filed a petition under Order 13 Rule 10 for calling up certain records. In this case, Lordship, the respondent number 3 and 4, before filing of the suit, the present suit, they have also filed a suit against some Rina Kedia, against the same cause of action, and same subject matter and same suit length. That has been dismissed for default, and that has not been revived till date. That particularly in my para 42 in my WS, I have stated that they have filed a suit by misleading some facts because on the same subject matter and same cause of action under Order 9, Rule 9, a separate suit has not maintainable. Therefore, I have filed a suit, I filed a petition to call for the record of the disposed case. That has been rejected by the Lord Trial Court. Against that order, I have come by this revision petition. And
That your
yeah,
prayer is
rejected. Since the case was already disposed of, no
But,
one
is
will be
there any-
prejudiced. Lord.
While passing the order of rejection, is there any observation by the learned trial court below that it was not disposed of on merit and all? Is there anything?
No.
Where is the order you have filed?
At page 93, Lord.
Page
Page 93.
92.
93.
93.
It was dismissed only on the ground that the plaintiff and WS all are public document in terms of section 74.
No. Once you have said that you have filed a petition for seeking some documents.
Yes.
Under Order 9, Rule 13 and whatever. And then again, you were saying that one petition was filed because other case record was dismissed. That was not called for or what?
Not called for. This is very much important for bearing of the case, Lordship. And no one will be prejudiced. The plaintiff will not be prejudiced. So that has been,
Your para 11 says it is observed that the
it is observed that the plaintiff side has admitted the veracity of a document. Part of disposed case number 91. We have paid for calling of the two records. One is 91/2022 from the additional district judge. There is
one is 91.
91/22 from the Court of Additional District Magistrate, Tinsukia, and title suit number 18/16, along with Ms. J case number 26 of 2016, both disposed of by the Court of Learned Civil Judge, Junior Division number 1. The present case has been pending at Junior Division number 2, and I have prayed for calling of the records from Junior Division in the same court complex. It will not take much time, and I am the defendant. I have to prove my case for interest of justice. No party will be prejudiced if calling of the
But
record.
it's observed in para 12 that it is pertinent to note that the calling of the entire case record would be a futile exercise, as the plaintiffs have themselves admitted the veracity of the said documents submitted by the certified copy.
Yes, they have admitted.
So the documents which were there in that case record, you have admitted that those are the.
Admitted in their objection, Lordship. In the suit, they have not mentioned anything about it. In their objection,
But those documents have already been admitted.
admitted, but there's
Those are the,
but there is some contradiction on the opinion of the different high courts. Whether WS plain are the public document or private document. Some say that it's a private document because it was already in the record. For that purpose, if there is a private document, original has to be called for proof the formal for formal proof. And no party will be prejudiced. There's a simple
that is okay. No parties will be prejudiced. So
If-
you are against this order only.
yes. And the suit is the plaintiff has not filed their evidence yet. The suit is at the initial stage. I have to prove my case by filing my evidence and all that. And for that reason, the calling of the record is necessary for interest of justice. Because every party should give a reasonable opportunity to prove their case. And court has the power under Order 13, Rule 10. Court may send any document from its records and call for any document from any court or proceeding.
That is today.
Either with one motion or on application.
So the plaintiff or the respondent side, they have already filed their evidence on affidavit or not?
No, Lord,
Not yet.
not yet. They have took several adjournments, but till that they have not filed their evidence.
Issues are already being framed.
Issues are framed. After framing of the issue, I have filed this petition. Before their evidence.
Administratively to be done. Sure. This is an application under Article 227. Section 2, challenging the interim order dated 2/8/2025 passed by Glarnett Civil Church Junior Division number 2 in Sukiya, whereby the petition filed by the present petitioner of the defendant number 1, number 875 of the 2024 in TS number 12 of the 2023 has been under order 13 Rule 10 CPC, call for the records of TS number 91 of the 2022 from the Court of Additional District Magistrate, from the records of 91 TS number 91 of the 2022 from the Court of Glarnett Additional District Magistrate in Sukiya, and suit number 18 of the 2020 or 18 of the 2016 and miss case number 26 of the 2016 record or disposed of from the Court of Civil Judge Junior Division number 1 in Sukiya was rejected. Issue notice to all the respondents to speed post and as their process. You take steps first, we see. Record here though we cannot, you have already filed the order. Do you need the record of this one?
Yes, sir. Well, till
TS
returnable
12
date.
oblique, huh?
Till returnable date. Proceeding may be stayed, Lordship.
But you are not going to prejudice anything there. Let them file their
Till
affidavit.
returnable date, Lordship.
Let
may be
them
disposed of
file their own affidavit. What will be harm to you? You will file.
A date may be fixed, Lordship.
This form or it will record. You need the record also. I don't think it is record necessary
No.
because you have already filed your order. You want any fixed date here?
Yes.
Fixed date. Your case is fixed on which date?
On the next 8th of January.
8th of January. So we'll fix it after Bihu. Okay. The date you can. 21 will do. Short date we're giving.
And an observation may be made, Lordship. On the next date, it will be disposed of because it's of small matter.
Oh, it may be disposed. Let them appear. Very small matter.
Obliged.
21. Yes.
Please, Your Lordship. My senior is out of station due to some personal emergency. So can you please adjourn the matter for the day?
Your MSA Roy.
R. Bhargav on
R?
R. Bhargav on
R. Bhargav. Or S. Sahu.
Yes.
R. MS R. Bhargav appearing on behalf. Mr. S. praying for an adjournment, stating that the Leonard's Angus Council is out of station. Prayer allowed. Please stay matter. After a week will do.
After,
After Bihu?
yeah, after 5th February.
After February.
Yeah,
February
after
1st.
5th, after 5th February. Yeah.
List matter first week of February as on date.
Wait, please, your lordship.
Yes.
The petitioners here are the tenants and a respondent in a title suit before the municipal Barpeta lordship.
Your
During-
petitioners are the tenants.
Tenants
Hmm.
under the rent control suit filed by the landlord.
Hmm.
During pendency of the suit, on closing of our evidence, DW3, an order was passed regarding calling of the official witnesses to prove the NJ cases, lordship. The original suit was mainly on the ground of for eviction on the ground of defaulter, bona fide requirement, and also prayer for arrears of recovery of arrears of rent. It is the allegation in the plaint that till 31/3 there is an agreement, and he served a notice, and we have not vacated. According to us, we have payment. We are paying regularly rent as the landlord refused to take. We have depositing the court. So during the issuance stage, we have submitted our list of witnesses, including the court official lordship. May I draw your kind attention to the page 24 of the petition lordship.
Yes.
DW3 is cross-examined in discharge. Point number 3. Then, since the petition number landed counsel for the defendant side with a prayer to examine the official witnesses, prayer was allowed. Next order I have annexed lordship at page 25 on 3/5. So that is the fair copy lordship. On 26 lordship, 21/11. The case is fixed for
Your-
evidence of the official witness.
No, no.
Page 26 lordship.
26.
6.
Acha. Ah.
The case is fixed for evidence of official witness. DW today, JAO Joyanta Thakuria is present on the receipt of summons, but he has not produced the requisite case records, stating that he has not been able to trace out all the case records listed in the summons. After the matters was taken up for hearing, learned counsel for the defendant has filed a petition for another opportunity to summon the said witness to produce the aforesaid documents. The learned counsel for the plaintiff, on the other hand, have filed a petition citing a judgment of the Honorable Guwahati High Court in the said petition, praying for rejection of the petition. Prayer be rejected. None appeared to make submission on the petition, fixing for hearing on order on 28/11. Lordship, the impugned order is at page 27, 28/11/2025, Lordship. After observing many things regarding the objection, NJ cases, etc., at page 29, Lordship, point 10. However, on the perusing on the prayers enumerated in the plaint, I find that this is a suit for eviction of the defendant on bona fide requirement of the plaintiff, as well as on the grounds of default of payment of rent. Here, the trial court has not added the areas of recovery of rent. Next part is the important part, Lordship, para 11. Nonetheless, nevertheless, no prejudice will be caused to either party if the case records of Miss NJ cases accumulated over the past decade. It is not the decade. Suit is pending since 2018, Lordship. Relating to the deposit of the rent are not exhibited one by one along with the evidence of the defendants. Rather, if need arises, the same can be called for and taken judicial notice at the time of argument. Petition number 2 is rejected and the petition number 2-3 is disposed accordingly. Case is fixed for argument. In CPC, there is, Lordship, there is no steps so more to taking cognizance of the NGO cases, Lordship. It is my case that I have depositing. It is their case that I am defaulter, and they have claimed for arrears of rent. If I fail to prove this NJ cases, Lordship,
But your
court will pass a
petition,
decree against me.
your prayer was allowed. You know, official witness.
Yes, that is earlier allowed, and suddenly, abruptly, it was closed. Official witness is not in my control, Lordship. Learned Munsif number 1 itself is the presiding officer of that office, Lordship. Controlling officer.
But is there any statement made by the plaintiff side that you have deposited through?
No, Lordship.
No.
No, that is the plaint, Lordship. I have annexed the plaint here, Lordship, at page 13.
No, subsequently, at the time of hearing those petitions, is there any?
Because there is a prayer of arrears of recovery of arrears of rent. though lawyer has made one in petition here, one submission has been recorded by the learned trial court. At the time of hearing, learned counsel for the plaintiff has submitted that they have not disputed the factum of deposit of rent in court. But on going through the plain lordship at page 12 and page 13, entire case is based on defaulter and the arrears of rent from 18 onwards, lordship. If I fail to prove, court will pass a decree against me for recovery of arrears because rent is almost 7,700. Here we are in the tenanted premises for last 15 to 20 years, lordship. There is an agreement of 11 months every time it has been renewed. In the last time, it has not been renewed. There is a specific clause, 20% of enhancement. We have agreed to that part also. So if we fail to prove lordship, every likelihood that we may be get defaulted, declared as a defaulter, and that arrears decree for arrears of rent that amounts in lakhs of rupees, lordship. And honorable court has allowed it. On the earlier occasion, 3524 court has allowed it, and abruptly without any reason, court has closed it. It is not in our control that NJ records are before this court. They are maintaining it. Simply we are producing it. Yes, we have deposited this much of rents. Our honorable High Court judgment is also there. We have to deposit proof that we are depositing it during pendency of this suit also. Otherwise, also there every chance that a decree for eviction will be go. Under that circumstance, lordship, I have challenged this order at page 26 onwards, lordship, at 27 onwards, lordship, 28/1/2025. Petition may be disposed ex parte if lordship pleases, because nobody will be prejudiced here. We may be allowed that yes, let the officer come and prove the records. It is his duty to produce the records. Otherwise, if he fails to one by one, then he can produce the register also. There is an NGO case register also. There is also concern, yes, we have deposited something. Records will definitely will not miss from the court. Order page 26, order 21 clearly stated. Thakure is present.
But then in para 10 of page 29,
Lordship.
it is also made an observation by the court that the suit is for eviction or for bona fide requirement. So
The
question
bona fide requirement in our humble
is
opinion,
you're-
lordship,
you're-
during
you're-
cross-examination.
you're considered as a defaulter also, na?
Defaulter. Main ground is because bona fide requirement has already been fallen flat, lordship, because he has 3 rooms at Barpeta Road particularly. 3 rooms, both sides is plain. If lordship goes to the plain, para 13, page 13 of the plain, lordship, schedule A1, page 13. North, other rented room of the plaintiff. South, other rented room of the plaintiff. In a building, there are 3 rooms. We are occupying the middle room. The property is at Barpeta Road. It is rented for last 20 years. It is not a residential property.
Heard Mr. S.K. Poddar, the learned counsel for the petitioner. It's an application under Article 227 of the Constitution, challenging the impeachment order date 28/11/2025, passed in title suit number 99 of 18 by learned civil judge junior division number 1 for PETA, by rejecting the prayer for recalling the DW3 with the documents and close the further evidence of official witness. Issue notice to the respondents through speed post and as usual process. Next para, considering the further submission of Mr. Poddar, if the proceeding in further proceeding in title suit number 99 of 18 is stayed till next date of listing. However, both the parties are hereby directed to proceed with the hearing of this case on the next date of listing, if the respondents appears on the next date. List after 4 weeks. Okay, we are listing it after 4
Obliged.
weeks of this post. Motion can I get? Read that fully. কোনোটা নাই বুঝতে এই নহয় না Dios mío, motion ima. Yes,
May I please, Your Lordship? Your Lordship, the respondent, he has filed a petition before the Learned Family Court under Section 10 of the Hindu Marriage Act
Hmm.
on 28th of November. A family member expired. Due to that reason, I could not attend the court. And I requested my family friend to represent me and inform the court regarding the demise. The petition which I have filed is on page 9, informing the court the reasons, sufficient grounds why I could not appear on that day. And Annexure 2, page 11, is the cremation certificate issued by the appropriate authority, Tura, why she could not attend the court. This is sufficient ground, Your Lordship, for the adjournment, but this petition filed by me on 20th of November, hearing number 2755, has been dismissed and my defense has been expunged. My evidence has been expunged.
where is your order? Order
Right.
is it?
Beg your pardon?
Your order is at page?
30, page 12.
This is the order.
Yes, yeah.
But here the order speaks that that is okay. You on that date you cannot could not appear. I mean, because of date of your family members, that is okay. But prior to that, in the last two
Prior to
occasion also,
that, prior to that, what has happened? The respondent, number one, he has filed a case in Shillong.
Hmm.
On 20th of November, that matter was listed before the Guwahati, before the Shillong, Meghalaya High Court. And I had to file a wakalatnama engaging a counsel over there. So I was at Shillong signing the wakalatnama and attending there. That was the ground why I could not attend on that day.
what nature of case he filed there?
That is the matter relating to Istridhan. He is not returning my Istridhan. I filed a petition also before the family court. That has not been considered. And without considering that petition also, that is the matter has been fixed for argument. That is disposal. I have filed a petition under 406 at Tura. And they have gone to Meghalaya High Court for quashing that petition. And under the circumstances, on 28th November, I was compelled to travel to Meghalaya, file my wakalatnama on that day. So that is the reason why I could not attend. And the respondent who has filed the case in Meghalaya, he was attending. He knows very well that the case has been fixed there also and the matter is fixed here.
On
Simultaneously,
the last two occasions also, have you filed any petition there for your
I have
seeking adjournment?
informed the learned court and I have given the cause list also. The cause list was enclosed. Your Lordship, that is if that is right to cross or my evidence is expunged, then that is violation of principal justice, Your Honor. Principles of natural justice. I'm not being allowed to contest the case then. Under that circumstances, I'm before your Lordship.
Part Mr. H. H.S. Kalsit, Learned Counsel for the petition. In application under Article 26 of Article 27 of the Constitution of India against challenging the impute order dated 28/11/2025 passed by Learned Principal Judge Family Court number 3, Kamrup, Guwahati in FC Civil Case number 843 of 2018. Next one, it is submitted by Mr. Kalsi, the Learned Counsel for the petitioner, that if the respondent had filed an application under Section 10 of the Hindu Marriage Act 1955 before the family court, which is registered at FCCB, case number 843 of the 2018, wherein the present petitioner as a respondent, your petitioner is a respondent, there, as a respondent had appeared and contested the case accordingly.
And moreover, there is a.
Your 3 DWs have already filed their affidavit.
We have already.
Accordingly, 3 DWs have already filed their affidavit. But on 28/11/2025, the present petitioner as a dependent could not appear before the Learned Family Court due to expiry of one of the family members, and to that extent, and in that regard, she also filed the adjournment petition before the Learned Trial Court, Learned Family Court, Learned Principal Judge Family. But in spite of, but in that case, have you annexed your the cremation certificate? No.
No, that is, I got her information. What WhatsApp I have sent the information.
No. Cremation certificate you have not annexed.
No,
yet.
that time it was not. It was not with me.
So could not so and so. But the petition was not considered by the Learned Principal Judge, and by order dated 28/11/2025, petition is dismissed, and the evidence of DW 1, 2, and 3 also stands expunged, was also expunged. And if next paragraph further submitted that the on 28/11/2025, the petition was filed intimating the date of the family member, and further he submitted that on the prior date, also she could not appear before the Learned Principal Judge Family Court, as she had to attend in a proceeding filed by the respondent before the court of Meghalaya, Shillong, and she was to appear to file her wakalatnama, and for that reason only she could not appear on the said date, and said that to that extent also she filed her adjournment petition, which was also accordingly allowed by the Learned Principal Judge. But in spite of the but the by order dated 28/11/2025, her petition for adjournment was rejected, and the evidences of DW 1, 2, and 3 had already also expunged, which caused great injustice and to present petition. If the petitioner if the petitioner is not provided with any opportunity to contest the case and produce the DWs for their cross-examination, the prejudice will be caused to the present petition, and hence the petition is filed seeking setting aside the order dated 28/11/2025 passed by the learned principal just family court number 3, Kamrup Metro, providing an opportunity to the present petitioner for cross-examination of the 3 DWs. Next one. Considering the submission made by and have also filled the case record and the annexures file and seen that on 28/11/2025, a petition was filed seeking adjournment for DWs, citing the reason for certain date of close relative of the petition. Further, it is seen that he had also filed affidavit of evidence of 3 DWs, and if an opportunity is not given to the present petitioner for cross-examination of those 3 DWs, the petitioner may be prejudiced, and considering this aspect of the matter and all the and other aspects of the case, I find it justified to provide an opportunity for the present petitioner to produce her 3 DWs for cross-examination. Accordingly, the order dated 28/11/2025 is hereby set aside, directing the learned principal just family court so and so to give an opportunity to the present petitioner to produce their RDWs before the learned court below. To stop, however, the petitioner is hereby directed to produce all the 3 DWs as on a date to be fixed by the court for their cross-examination. The above observation presented CRPU is hereby disposed.
Obliged.
Where please, Your Lordship, here the respondent husband, he filed this suit before the principal just family court 3 Kamrup Metro, Your Lordship. Due to his consecutive absence more than 3-4 times, suit was dismissed on 8/11/2024. Your Lordship will find at page 12. That is the order. I am for the wife. Here is the petitioner. Petition, page 12.
Case was filed by her only. Filed by whom?
No, suit was filed by the husband.
Husband.
Here he is the respondent.
Seeking divorce.
No, for the guardianship.
Oh,
Guardianship of the minors.
Okay.
And what happened, my lord? After filing of the suit, he remained consecutively for more than 4 times.
That was dismissed.
That was dismissed. So after dismissal of the suit, my lord, he came after 4 months before that principal just family court by filing an application for restoration of the suit under order 9, rule 9.
With a condonation.
Yes, without any condonation of
Without any
condonation of deal.
Achha.
And that too, my lord, in his petition also, there was no whisper regarding that. There was no any effort to explain regarding the delay while filing the petition. That was also not there. And without considering that aspect, Your Lordship, that learned court below has passed that impure order. The relevant portion, Your Lordship will find at page 32, para 7. Page 32. Para 7, it is reflected. Peruse the case records and materials on records. Perusal of the miscase so-and-so reveals that by order dated so-and-so, the said case was dismissed for default of the petitioner. It further reveals that the instant petition was filed by the petitioner and so-and-so after nearly about 4 months of the dismissal of the so-and-so without condonation of delay petition. That is observed by the learned court below. and without condonation of delay. But however, the absence of petitions for condonation of delay will not debar the petitioner from claiming so and so, Your Lordship. That was the so far observation by the learned principal judge. But so far, the Family Court Act, Your Lordship, the section 10 of the Family Court, the procedure generally, my lord, it provides, section 10 of the Family Court Act, it provides, in case of any suit proceedings, the Family Court has to deal with those proceedings, suit proceedings,
As a civil.
as a civil. It is clearly mentioned. And so far, limitation act is there. 30 days is the limitation. And that too, he has come after 4 months without any condonation of delay. That is the abuse of process of law, Your Lordship. That is my humble submission. And for that, I have come before this honorable court. And in my objection also, I clearly stated about that. At page 29, this is my objection in that application, my lord. Para 8. The deponent Swens of Father begs to state that the instant applications filed by the petitioner is barred by limitation. More so, there has not also any whisper in his application regarding such delay. His application has been filed in a very placid manner. As such, the application of the petitioner is not bona fide. I put an objection in that application also. In spite of that, and without adhering to the procedure, my lord, that order has been passed. This is the grievance of the petition.
Mr. Debora, application section 151 CPC against the order dated 11/9/2025, passed in mistake case number 29 by learned principal judge family number 3 M, arising out of Miss G, capital G, case number 131 of 2022, whereby the prayer for restoration of Miss capital G, capital G, case number 131 was allowed. Issue notice to the respondents through speed post. Call for this kind of this year.
My humble prayer, my lord, the proceeding may be also stayed till a return.
Further considering this submission made by Planet Council, let the further proceeding be stayed till next date of listing. Next date of listing. Simple. It will be
Much of
4 weeks.
In this case, I have, my lord, prepared this petition against an order dated, my lord, 2011-2025. It is 133. My lord, in this case, my lord, the other side, my lord, opposite party responded, they filed a title suit of 2003 of 2026, my lord, 2006, my lord. So that was decreed on 3/1/2012. Then first appeal was also, we preferred a first appeal, that was dismissed, my lord. Then, my lord, we filed a second appeal. That is RSA 19 of 2019, my lord. And this appeal was admitted by this honorable court on substantial question was framed. And, my lord, the execution of this decree was stayed, my lord. That, my lord, will find at page, my lord, the 20, my lord.
Date?
Page 20, lordship, Annex 1. My lord, may come to page 23. That is the, my lord, first title, page 23. The regular second appeal is admitted, page 23. That is admitted, my lord. Then, my lord, will find the stay order, my lord. That is page, my lord, 26. Same, my lord. Now, lordship may look into page 27, my lord. Having considered the facts and circumstances of the case, and the submission of the learned counsel appellant is for execution of decree still remains suspended, my lord. Now, my lord, on the basis of the another suit, that was 2002, because it is the same party, same day, same piece of land, my SIP state land, my lord, and the suit was filed, my lord. Against that, the preferred and final title execution suit, my lord.
Title?
Execution suit, my lord. Title execution case, my lord. That, my lord, I'll take my lord to straight away, my lord, to page, my lord, page, my lordship may come into page 106, my lord. Title execution case of 19 of 2016, my lord. Title, my lord. Now, my lord, here lordship will find the.
When it is filed?
It was filed in, my lord, 2016, my lord.
Oh, yes, 2016, and your stay was when?
Stay was on 2000, my lord, 25, my lord.
No.
Now, yes,
Your,
sorry, my
execution
lord. It was
order
on
of
2019,
execution
lordship.
was on
It is 18/1/2019.
19.
19, lordship. I'm sorry, my lord. So it is still holding, the RSA is pending, my lord, for disposal. Now, lordship will find from this page 106, my lord.
No, that was announced. The question is that this title execution
Yes, my
was filed on 2016,
16, my lord.
and thereafter you have preferred in 1st April, 2nd April, whatever. In
Ah,
2nd
yes.
April, there was a stay.
State, my lord. In second April.
Now what?
State.
Yeah, in 2nd April, there was a stay.
Yes, my
Now what is the case now?
Now, my lord, they filed a execution suit, my lord, in respect of a land involved in the title suit number 202 of 2006. That is another suit between the same parties regarding same suit claim, my lord.
No, but your suit then is on title execution 19 of 2016.
Yes, my lord.
So now?
Now, my lord, we filed an application for stay of this execution because of the pendency of the second appeal. Because a stay has already been granted in the second appeal, not to execute a decree.
But that title execution case was
Yes.
The present.
Yes.
After the present title execution case was filed
Yes.
for in connection with which case?
In connection with TS number 202 of 2006.
Again,
my lord, it is between the same parties. Therefore, we filed an application, my lord, that you since because this RSA is preferred against the decree and the judgment and decree,
Yes.
which involve the same suit of land, and High Court has stated the matter, my lord. So this also should be stayed till the appeal is disposed of by the second appeal is disposed of by this honorable court, my lord. So that was rejected, my lord.
your subsequent second your title.
Yes, my lord. That
case
is what it is of 2011-2025, the order, my lord.
2011.
11/2025, page 133, my lord. The same court is dealing with both the cases, my lord. All the records are there before the court, my lord. So we file.
Subcase, I think.
Yes, my. Same drug number, same button number, same, my lord.
But the court had observed in the order,
My lord, I
specifically
still-
observed that the suitland are different.
My lord, now I take my lord. If your lordship
Both are
look into,
different. Because
uh,
one is connected to 2002,
I
2016,
have
and other
already
one is
submitted.
2003,
I have already
2006.
submitted my.
I submitted that, my lord. If your lordship now look into
Now
this,
how it will be?
my lord,
It is
if
not
your
okay.
lordship look into page 107 is the schedule of the land.
Whatever. It's separate.
My lordship will see the district Kachar so and so, Pargona so and so, Dag number 322, land measuring 1 bigger 4 kata and 5 shotak, my lord. That is the land also involved in the both suit. And if
Anyway,
you're
it cannot be a case. Anyway, now this title execution is pending.
pending, my lord, it is on 8, it is 5 for money execution of the writ, my lord. 8 January, my lord. So I have
The
no.
suitland are so different, it seems.
Now, if your lordship look into page 91, my lord, will find page 91.
So
my lord.
why two suits are there then?
My
One
lord,
is of
I am the defendant, my lord. I am the defendant. They have filed the suit, my lord. See,
But it is clearly observed in the order that there are two suit lands. And
My
that's
lord-
why two suits are there. One is definitely.
yes,
it is also
yes, my
discussed
lord.
that the-
But the
the
land
RSS
involved,
so it
what
is
I
stayed.
respect submission is there. The land involved, my lord, in the boards the same. Parties are the same. If your lordship
Parties
look
are
into
same.
yes,
Suit land are not same.
my lord, if you lordship look into page 91, my lord, for the time being. 91, lordship will. Lordship 91, my lord. It is on the right hand side, my lord. The decree has been prepared like that. Lordship will find an area of land measuring 1 bigger 4 kata 5 places in Dag number 322, in RS Patna number 23, Mauja so and so. Same quantum of land.
So in that dark, what is the quantity of land fall under that dark?
One is my lord, 1
That
bigger
may be
4
same.
kata 5.
The
That is the
suit land may
suit
be
land involved
different.
in both the case.
No. In one dark,
Yes.
there may be two separate land, no? One kata same lesa, one kata same lesa.
Yes, my lord.
It may be there.
But it is the same suit land, my lord.
Your
Described, yes.
boundaries are also same. I don't think
Same
so.
lane.
Boundaries are not
That
same.
is as per the decree prepared by the trial court.
Boundaries are not same.
But boundaries are thick. My lord will see
Same.
east
That
land
is the case.
315.
That's why it is
Land,
identifiable.
yes. So,
It's not same.
suit land of Dag number 323.
Yes, dark number is there.
Yes.
I'm saying whether it can be identified as the same. suit
That is
land
my
or
lord.
not.
That has to be determined, my lord. That has to be determined. Section 47 says, my lord, all the question regarding the execution, my lord, the decree should be decided by the trial court. So they should decide it, my lord. Simply saying that these are not, my lord, they identical will not do, my lord. There should be adjudication because no separate suit is like I can file against that, my lord. Section 47 of the, my lord, CPCFA law should look into. Section 47, my lord. Section 47 says, my lord, question to be determined by the court execute decree. All the question between the parties to the suit in which decree was passed, what they represent
And
related.
your prayer is of title execution 19/2016.
Yes, that is the only case, my lord, 19 of 2006.
No, but this title execution is numbered as of 25 only.
No, my 19, my lord. Lordship kindly say page 106. Page 106, my lord. '06, 19. Yes, my lord, on the top.
No. Separate execution is. The next second execution is numbered as.
No, there is no second execution. It is the only execution. Only execution, my lord. No second execution.
No, Ms. J 408. What is it?
That is, my lord, miss case. We have filed for stay of the this execution, my lord.
That was rejected.
Yes, that rejected by 2025 order. Against that, which I am before your lordship.
But here court has not passed any order on in connection with 20. Your original case was 202. 202.
No, 202, my lord.
202 of 2026 is not passed any order. It is on purely on 203 of 2026.
Yes, Well, in 203, we filed this, my lord, petition.
Sorry, 203, but in
Ah,
this case,
yes,
it's
yes,
purely
yes,
on 202 only.
Yes.
This execution on 202.
It is on 202, my lord,
Yes,
petition.
not 203.
203 has already been stayed by the
Ah,
honorable
yes,
court.
so it is
High court.
202 only.
In High Court is honorable High Court has already stayed execution or
So
decree.
it is
Therefore, I
not
need
in
not to.
connection with 203. It is connection with 202. only.
We have filed this petition.
202
Title execution suit, my lord,
No,
belongs
in
to 202.
which was the earlier execution case number?
19 of 2016.
No, that is for 203.
202.
Oh, sorry, 202.
Yes,
Now,
my lord.
203, where is the 203?
203, we have already stayed, my lord. No decree,
stayed?
no execution has been run.
No, in title suit number 203, there is no stay order. In title suit number 202,
Yes,
wherein you have filed the first appeal, then second appeal,
Yes.
second appeal, it has been stayed.
yes.
Now, what about the 203? Oh, sorry, 202.
202, my lord, the suit has been decreed.
Huh,
On the
this is the
same,
202 only.
same suit lane.
This is the 202 only.
Yes, yes.
Could have clarified these things before the while your order was been passed in RSA. Then in that time it could be clarified.
My lord, because my lord, we have challenged the decree
But
of
now
Tulsa.
this case is of 20, the order has been passed.
Yes, my
This
lord.
press order has been passed only for in connection with 203 only,
20
not 202.
202, my lord, not 203.
Oh, sorry, 202.
Yes, my lord. That is why I brought
Your
this
one
to
is
the-
203 only.
Yes,
Ah,
that is why I
not
bought this
203.
notice. Both the suit line is same.
Your case is 203
Yes,
and
203.
it is order is of 202. That is
That between the same party, same suit line.
no, you have taken the pleas on that argument stage only. Now how can we say this is same? This is not the same. You cannot say it. It's a
My lord,
separate
that has
suit.
to be in my
This
humble-
execution has been filed under the separate suit of 202,
two. Yes,
not
yes.
for 203.
Yes, my
At 203, you have already
because we
obtained
have
a order
why
of
we
stay.
filed this objection in the 202, my lord, because we said in 20 the suit line involving 202, 203 is the same suit line.
Can you say?
Uh,
Now,
yes,
now how
that-
can you raise
my
it
lord,
on that?
that- no, my lord.
Against the 203, whether, oh, sorry, 202, whether you have filed any case, any appeal, any second appeal, any first appeal, any appeal.
No,
you have
my
not
lord.
filed, you have not
No.
challenged the order of decree.
Yes,
Now how can
but
you take
the suit line is the same, my lord. Suit line is the
root
same.
suit? Maybe same. The
Yes,
order
my-
is there, very specific order has been passed by the court.
Yes.
There's a separate identifiable land.
No,
It's
my
not
lord, that
connection
has to
with
be determined.
203.
There is no determination as such.
It's there only.
Well, there
That's
is
why
no
your petition was rejected.
yes.
Now, what is the stage of the decree it passed in 203? Oh, sorry, 202. What is the case now?
Now,
Do you have any case now? No.
my
There's
lord,
no cases pending.
it is,
Against the decree of 202.
it is
When
my lord,
against-
execution is pending. 202.
Oh, you have not challenged it order decree of 202.
No, my lord.
Then?
We have challenged the execution proceeding there because of this stay granted in 20 because it belongs to the same plot of land, same suit of between the same parties. Between
No,
the same.
whatever, but after the decree passed in 202, you have not challenged it.
Not challenged, my lord. That is
Then
that
you
is
have
true,
not
my
challenged
lord.
it. The
But
decree is already there.
in 203 same suit line, my lord.
Decree
Now,
is
if
still in existence.
my
You have
lord,
not-
my submission is this: if the title execution executed, my lord, then what will happen is the stay. It will be the same suit of land. What happened is the stay order passed by this
Oh,
honorable
yes,
court,
but the order is
RSA.
not the same suit of land. You could not say the boundary. Boundary is different boundary.
That has to be
Suit land is
decided.
different boundary.
My lord,
They
that
cannot
has
be
to-
identified as the same.
My lord, that have been
That is the
decided
case.
under section 47, my lord. Without deciding.
Yes, under
Yes.
section 47, 99.
Let
it's
them
okay.
decide. What
Let
I
them
respectfully
decide, that's
submit,
good.
my lord, all the records are before the trial court, both the case. Let them decide. 47.
So you have not filed any 47 there.
Let them
You
decide,
have
my
not filed any 47 also.
Yes,
is the
my lord.
47?
That,
You have not filed any 47, 99. You have not filed.
my lord, that is the
Oh, you
thing,
have
my
not filed 47. Why don't you file a 47 there before the court itself? 47 a very good ostra. You can file it. Oh, yeah. Many matters have been decided in the under 47.
In this case, my lord, so my lord,
We'll issue the notice first.
Notice,
Now,
my lord, yes.
we'll issue notice.
yes, my
Let the matter be clarified.
yes, my lord. That-
Because it's a case I have seen
Yes.
the boundaries are different, totally different boundaries.
my lord, will
Two cases were there. Maybe out of before for the same parties between the same party that is understood
Yeah.
between the same party, but identifiable. This land is identifiable. That is the question. Anyway, We'll issue notice first.
My lord.
Heard Mr. PJ Post. This is an application under Article 227 Constitution of India, dated Section 1 CPC, challenging the impound order dated 2011-2025, passed in means a case number 454/2025 by learned Civil Judge Junior Division number 3 in title execution.
19 of 2.
Is it title execution 19?
19, my lord. Title execution case number 19 of 2016.
Nowhere it is stated it is a title of 1927.
Should have mentioned, my lord.
No.
They mentioned
Here
it over there.
mentioned. Here too it is not.
My lord,
all
in our
mentioned.
petition, we have mentioned.
No,
They have also mentioned.
In order passed by the learned track,
Ah,
there is no
they have not
mention
been
at all.
mentioned, my lord.
arising out of so and so.
It should have
It's
been
not-
mentioned by
not
the trial
mentioned,
court.
not mentioned. So now
Lordship
very
will say,
difficult on our part to say that it is out of title execution so and so. It's nowhere mentioned. It's not here.
there is a petition under 151, my lord.
Yes, it's one.
Yes. Now, it has
is
been
not-
mentioned there in para 3.
You have mentioned that it is a title suit, but it's not here mentioned.
My lord, in para 3, my lord.
No, it is mentioned by you only, but it is not mentioned in the by the court.
Yes.
Whether it
Yes,
is out
it
of
mentioned.
same execution, it is not here. Because now see, decree in two separate suits cannot be executed under same title execution.
Yes.
Title
Yes.
execution number has to be two different title execution.
Mm.
You have not annexed anything here. How
They-
can we say that out of 203 and 202 same title execution? Same title execution cannot be.
There is only one title execution.
One title execution.
Yes.
If
That
two
I said,
decree,
it
how
is
can
submitted.
one two?
Only
There has
one
to be
title
two
execution.
title execution, not by one.
Huh.
And Nilipok stay of execution proceeding due to pendants. Another note that execution number 19 of 16. Order to challenge for video. Asked in connection with issue notice. Court eliminates. Issue notice to all the respondents
Yes.
through speed post, digital process. The we call TCR call here in the cost title,
Lost.
you have mentioned another number, execution 19 of 2026 also.
16.
This is a mistake, I think, na?
Mistake,
wrong.
my lord. That
Ah,
is a mistake.
Should notice. Courts.
My lord, at least, my lord, the status quo as on date may be meant till next date, my lord. Otherwise, my lord, or
This is different. How
my
can
lord.
you have already got obtained
My-
your stay in RSA.
Mm.
You are
My
listening
lord, in
after-
view of that stay in the RSA, that is why I am submitting. That is why, my lord, in view of the RSA. Obliged.
With pleasure, Lordship. In the year 2010, we have filed a suit for recovery of possession and declaration about title and cancellation of some sale deeds. The gist of the case was that one of our my cousin brother of my father, have got some sale deeds, fraudulent sale deeds in his name, and on that sale deed, they have forcibly taken possession in 2008 or 7. Thereafter, we have filed the case at Bongaigaon, Civil Judge Bongaigaon. Then that was transferred to for change of jurisdiction to Munse. After completion of the evidence, Lordship, we have filed one petition for sending those sale deeds, challenged sale deeds, to the FSL for examination of the fingerprints. Along with that, we have filed a petition. Lordship, one affidavit we have executed in the year 1989 by our father, putting his thumb impression at that time before a magistrate, judicial magistrate, and filed a petition under 714, Order 17, Rule 14, that this affidavit be taken on record let us produce this affidavit as a part of our additional evidence, and then the additional evidence at the cell dates, those question cell dates, be sent to FSL. Learned trial court, after hearing both the sides, have by impugned order, which is we have annexed at page 63, Lordship, rejected our prayer of order 7 rule 14.3 for accepting the allowing us this additional evidence and the document. Because 14 order 14 says all the documents normally have to be filed along with the plaint. We could not file that affidavit, Lordship. 14.3 says, Lordship, here, a document which ought to have been produced in the court by the plaintiff when the plaint is presented, or to be entered in the list to be added or annexed to the plaint, but is not produced or entered accordingly, shall not, without the leave of the court, be received in evidence on this behalf at the hearing of the suit. Lordship, as we have not filed that document, we have filed a separate petition seeking leave of the court. After hearing both the sides, by the impugned order dated, Lordship, at page 63. May I read the first part, Lordship? By petition number, the learned counsel for the plaintiff has submitted that the plaintiff have filed an affidavit shown by Kalu Bhuya, our father, on 9/8/89, after closure of the evidence of both the parties by a Firisti and plaintiff were to file a petition under order 7 rule 14.3 as amended up to date, praying for leave to file the aforesaid document on the date of its filing, but due to inadvertent mistake, the said petition was not filed on today. Upon hearing both the sides and raising objections, etc., the operative part on this petition is, Lordship, has been rejected. The document has not been admitted and no leave was granted, Lordship. That's why we will be deprived from getting the cell deed, proof of this execution of the cell deeds to be get examined, verified by
for FSL was your prayer for
the
FSL.
cell deeds. The thumb impression, we are challenging that the thumb impression put in the cell deeds are not of our father. Those are fraudulent. That is the initial stage. Lordship, we are out of position. They are in position. So there is no question that we are getting benefit from delaying the matter. They are in position. Our suit is for recovery of possession, Lordship. Learned trial court should have allowed our prayer, leave should have been granted to us, and then to send it. Otherwise, the other part has been allowed us. Survey of the land case is fixed on the February 2nd week, Lordship, for the report of the demarcation of the suit land, because it is also disputed.
The prayer for commission was also filed by you.
Yeah, that is also filed by you. That has been allowed, but the petition, so far leave is concerned, is rejected, Lordship. And we have before this honorable court for allowing us to produce that document, and then both the documents can be sent to, unless a document has been produced before the court, court cannot send it as an admitted document. At page 68, the operative part, from the case record, it appears that the plaintiff had submitted the certified copies of the cell deed as such, thumb impression of the is not available in it. We have already proved the certified copies, original certified copies, because those are with the defendant side. We have challenged those, and those are exhibited by the defendant.
So now your thumb impression, which was put in by your father in 1989.
In 1989, Lordship.
1989.
Before our judicial magistrate, Lordship.
It will be compared with how? How it will be compared?
With the cell deeds, Lordship, that the defendants have with them. They have produced those. The defendants have produced their cell deed, and we are challenging those. Here the observation at page 68, Lordship, second paragraph. Totally misread our prayer and comes on the merit, Lordship, of the case. Because only after admission of that part, this further petition regarding sending to the FSL or non-sending to the FSL will come. Before that, court has opined certified copies of the cell deed and submission cannot be available. That is not the fact, Lordship. Here our petition is confined to granting of a leave to get the document admitted. By way of only one evidence, additional evidence, yes, this is the cell deed executed. Then the question of petition which is kept in abeyance regarding sending to the FSL. We have prayed that let our petition be first decided the 714 leave, then the matter will be taken up for sending by giving a copy to the other side.
Your affidavit was available with you na at the time of filing your thing.
No, that was with you, but due to inadvertent mistake, we could not file it. That is an admitted position. Due to some inadvertent mistake, we could not file it. And it is between the family, same family. The total property between the same family lordship.
Is there any interim prayer from you?
Pardon, lordship?
Is any interim prayer is there also?
Interim period is there, lordship. Stay of the, because case is fixed for now report of the survey proceeding, lordship. 23rd of February has been fixed, lordship. So for my information is there. For the demarcation part.
Let the survey be there. So it is your prayer only.
No, that may be there, lordship. So far, because court may, on receipt of survey, court may go for argument because evidence has been closed, lordship. So for that part is there, argument should not be. So for disposal part is concerned, it should be on that line.
But Mr. SP put that in the constitution. Alleging the order dated 1/8/2025 passed in Title number 107/21 by Learned Civil Judge Junior Division North Samara, whereby the prayer for for filing additional document, filing some documents which was filed under Order 7 Rule 14(3) of CPC was rejected by the learned trial court below. So, issue notice to the all the respondents to speed post. Next, further considering the submission made by learned counsel for the petitioner, Mr. Poddar, the further proceeding in title suit number 107 of 2021 we state till next date of this list the matter accordingly after as on the date to
Apply.
Look, I am appearing for the petitioner in this case.
Pardon?
I am appearing for the petitioner in this case.
Yeah.
Yes. My lord, case of the petitioner before your lordship is that there is a title suit is pending again in the Court of Civil Judge Junior Division between the above named parties. What happened, my lord, while admitting the title suit and an injunction and petition miscase for injunction was granted in favor of the plaintiffs thereof, wherein I am participating as defendant number 4. And other defendant number 1, 2, 3 has not participated in the and filed any objection with regard to the injunction granted in favor of the plaintiffs, but and contesting the suit of the plaintiffs by filing written statement thereof. And but the learned trial court has granted injunction, a temporary injunction in favor of the plaintiffs over the suit length. And on being aggrieved with the said injunction order, I have approached the Court of Learned Civil Judge Senior Division in the said district. But that was also refused by this. For that, I approached this honorable court for.
That Miss Appeal was also rejected.
Yes.
Dismissed. Mr. Paul, na?
Yes.
Your
I
name
just
is not
filed Okalatama
reflected.
today, along with the other my friends.
So how will write now? Mr. Mira's name is there, Mr. Rahman and
Assisted by Mr. Mira.
Mr. A. Paul, the learned counsel for the petitioner, assisted by Mr. K. Mira, counsel for the petitioner. Petition under file under section 115 CPC, related with section 227 of the Constitution of India, challenging the imprint order dated 27/8/2024, passed by learned Civil Judge Director Senior Division, Hailakandi in Miss Appeal number 2/2024, by which the order dated 18/1/2024, passed by the Court of Learned Civil Judge Director Junior Division, number 2, Hailakandi in Miss J case number 91/2022 was affected. Issue notice to all the respondents and through a speed post and as usual process. Also call for the TCR. Stop. Let the matter be listed after 4 weeks as on a date to be by the list. So we are issue notice. We are listing it after 4 weeks. As
Publish.
motion is খালি one motion আছে। থাকলে হল কারণ মোশন সব মোশনতে আছে এটা। না না ঠিকই আছে দিছে ন ন পকাই দিতে পারবে নি ini aku motion ini bubar মানে মোশন কিমান টাইম হল যে আমি বিও বলে পেতে পান পাইতে পারবেন মোশনতে কি টাইম বুঝি সে একো নাই আৰু ইমান বন্ধ আছে যেটা উপায় নাই পকাই দিলে হয় আৰু yes sir
May it please his lordship.
Mm.
Lordship, impugn order in this case is lordship. I have filed an application under Order 1 Rule 10 that has been rejected. Before coming to that, let me summarize what is the case all about. I am one of the, my father is one of the 5 brothers. So there was a piece of land in 2 places, one in Lanka and the other is in Nagaon. So in the place where I am, that is in the Nagaon land, that was given to me by gift by my mother. Now, we have been living in that land for a long time. Subsequently, in the year 2020, the other brothers, some of the brothers, that is the defendants in this case, they have come and tried to evict us. And they said that this is our land now. So when we inquired, we came to know that they have illegally mutated their name over the land. In the year 2021, I have filed a title suit claiming right title interest over the land, and also I have come to know that there was an agreement for sale, and I have challenged that agreement for sale in the title suit in the year 2021. Now, Lordship may kindly see the prayer in my title suit. Lordship would find that in page number 22, the schedule is in page number 32. The title suit starts from page number 22, and the prayer portion, Lordship will find at page number 30. Lordship found it. A decree be passed declaring that the registered sale agreement to sell number so and so as described in Schedule C of the plain are illegal, inoperative, void, and unenforceable. Now, Lordship may kindly turn to page number 32, and that is the schedule C1. So this is the agreement for sale. Now this I have challenged this before the civil court in Nagaon. They have appeared. The opposite parties have appeared, and both the parties of the sale, the vendor and the seller, the vendor and the purchaser are made a party in the title suit. So they have filed their written objection, and the other legal heirs, I have also made them a party. So during the pendency of the case, they have filed a joint.
Seller means that it was an agreement for sale or
Yes.
it is already executed. No,
No, not executed. Only agreement for sale that I have challenged in the title suit. Now, I have been granted an injunction order also, my lord, in that lower court. And then I have, during the pendency of the case, a joint petition was filed by the other defendant. The main contesting defendants, that the seller and purchaser, they have not filed any joint petition, but the others have filed a joint petition saying that we have no problem if the suit is allowed in my favor.
That is me, your other brothers.
Yes, yes. So that story is a different story. Now what happens, that joint petition order was passed on 27/2/2024. That lordship would find in page number 55. Subsequently, when they came to know that the other brothers has no problem, they have filed another title suit. In that title suit, the purchaser has filed a case for specific performance of contract against the vendor. Now, lordship, that case was filed after this joint petition. It was filed on 3/6/2024. Title suit number 80 of 2024. However, in that case, I have not been made a party, because according to them, this is a dispute between the two purchaser and vendor, and specific performance of contract does not cover me. When I came to know of this, I have filed an application for Order 1 Rule 10, saying that
Including you as a party.
yes, because this same case is going on. I have challenged that, but then they have not made me a party. So they have filed an objection, and subsequently the learned civil judge has rejected my prayer, saying that the operative portion lordship would find in page number 110. Moreover, in the event any decree is passed against the defendant and in favor of the plaintiff for specific performance of contract for sale in respect of the contracted property, the decree would be passed in the suit. Obviously cannot bind the petitioners. In that case, petitioner would be at liberty either to obstruct of execution in order to protect the possession by taking recourse to the relevant provision of CPC, or to file an independent suit for declaration of title and possession against the plaintiff and defendant, which is in the instant case they have already filed, being title suit number 133 of 2021 in the Court of Learned Civil Judge Junior Division number 1 in Nagaon. It is well settled that a suit for specific performance of contract for sale, the list between the plaintiff and the defendant shall only be gone into, and it is not open to the court to decide whether the petitioners have acquired any title or possession of the contracted property, as would not be the germane for decision of a suit in the specific performance of contract for sale. And that is to say that the suit for specific performance of contract for sale, the controversy to be decided raised by the plaintiff against the defendant can only be adjudicated upon. And in such a list, the court cannot decide the question of title and possession of the present petitioners relating to the contracted property. So this was the view of the judge, and in my humble submission, this cannot be the view of the judge. And lordship, I'm praying that notice should go and the suit may be stayed, lordship, because this is not the fundamental
process. We don't need any scan copy here, I think.
No.
Because order you have already annexed.
I have already annexed everything.
Next pardon, further considering the submission made by Mr. Deck, the further proceeding in in title suit number
80 of
2024 be stayed. Next date of the state. Next accordingly after 4 weeks as on a date to take steps so that matter can be decided at the earliest.
Highly appreciate.
Please, Lordship.
Yes.
Lordship, this is a civil revision petition. The petitioners before your Lordship, they are the defendants of the suit.
They are the defendants.
Defendants. The plaintiffs, my lord, they have filed the instant suit praying for, my lord, the perfect partition of the suit land, recovery of possession.
Partition also.
Yes.
Partition.
Yes, they are claiming that it's an ancestral property. So therefore, they are claiming for a decree for perfect partition of the suit land, recovery of possession, delivery of pass and vacant possession to the plaintiff, issuance of
precept to the circle officer for mutation, restoration of plaintiff's name in the revenue records. And my lord, the suit has been registered, and presently the suit is pending for, my lord, evidence of plaintiff's name.
Evidence for plaintiffs.
Plaintiffs. And my lord, we have filed our written of statement, and thereafter, my lord, this learned trial court was pleased to frame certain issues, my lord, certain issues, and thereafter, my lord, on my lord 3/11/2025 also, my lord, the plaintiff number 1 and 2, my lord, there are two plaintiffs. They have submitted their evidence in the form of affidavit. On that very day, my lord, we have filed an application praying for framing of additional issues, my lord, certain additional issues, my lord. Lordship will find it our petition at page number 48. Page number 48, my lord. And it's an application under Rule 5 of the Order 14 of the CPC, praying for framing and recording additional issues. And this is the petition, my lord. And the proposed, my lord, the additional, my lord, the issues which we have suggested, my lord, that is at paragraph number 6. Paragraph number 6, that is at page number 49. Well, my lord, on the very day, my lord, the learned trial court, my lord, instead of deciding these issues, my lord, whether, my lord, the issues which we have suggested, my lord, whether that requires, my lord, whether that is necessary or not, without going into that aspect, straightway rejected my petition, my lord. Lordship, page number 54. My. Page number 54 is the impugn order. My lord, I am reading, my lord, both parties are duly represented. The learned advocate for the plaintiff filed evidence in affidavit of PW1, namely so and so and so and so. PW2, namely so and so, along with their copies. Copies of the same are received by the defendant side. The learned advocate for the plaintiff side heavily prayed for another date for filing evidence in the affidavit of remaining PWs. The learned advocate for the plaintiff filed a petition bearing number so and so under Rule 5 of the Order 14 of CPC, along with its copy, praying for framing 12 more additional issues. It should be, instead of plaintiff, it ought to be defendant. Record reflects that, this is important, record reflects that on 9/6/2025, by perusing the pleading of the parties, 10 numbers of issues had been framed by this court, and subsequently the case was fixed for list of witness, which were submitted by the parties on 5/7/2025 and 21/7/2025. Thereafter, on 11/7/2025, this case was sent for mediation, which returned unsettled, and on 29/8/2025 and 25/9/2000, this case was fixed for evidence of PWs. Today, the plaintiff side filed evidence of PW1 and PW2. Now, this is important, my lord. Considering the stage of the suit and issues framed earlier, the petition number so and so is rejected at this point of time. However, it is made clear this court may frame additional issues if found necessary. The court has not gone into the issue, my lord, whether the proposed issues which we have suggested, my lord, whether that was necessary.
The earlier period of time, you have not filed any your these draft issues you have not filed?
My lord, draft issues we have submitted, my lord, but that was not, my lord, as per our issues which have been framed, my lord. That was not as per the draft
issues you have filed.
Draft issues we have filed.
Earlier you have filed your draft issues or not?
Draft issues, as per my instruction, we have filed, but all the draft issues, my lord, which we have suggested, my lord, those were not framed, my lord. Here, my lord.
See, there are draft issues filed by plaintiff side and the defendant.
Yes.
The court is the case to decide which are the important issues has to be decided, because if you file 17 issues, other side file 15, it's not necessary for the court to discuss all these issues.
True.
But yes, definitely, if there is any issues which is need to be framed by the court,
yes,
that has to be there. But now I have seen your petition.
Yes.
There are as many as one.
Yes. Though in the suggested there are 15 issues, mother.
10, 11, 12. Now again, the present petition also, the petition which I have filed before the court, You have suggested 12 numbers of issues.
No,
Now,
that
what
is-
are the issues?
That is there, but my lord, it's not that I am praying all for all these, my lord, because in my lord, page 13, my lord, page 13, if your lordship, my lord,
Well,
kindly
page
see,
13 means?
page 13 of the petition, my lord. Page 13, my lord. So my prayer is not to frame all the issues, my lord, which we have, my lord, suggested, my lord. It's not like that, my lord. Paragraph 13, my lord. My prayer, my lord, point number 5, my lord, direct the learned trial court to frame the additional issues as sought by the petitioner, more particularly whether the suit is barred by limitation, whether the state of the common ancestor already stood orally partition among the parties or their predecessor in interest. Because, my lord, our specific stand in the WS is that the property in question, my lord, for which they have, my lord, claim from my lord, partition, my lord, that has been orally partitioned. So that is very important issues to be framed, my lord. Next, my lord, whether the civil court has jurisdiction to adjudicate disputes relating to entitlement and apportionment of compensation arising out of land acquisition. Here, my lord, why I am suggested these issues, my lord, because there in there, my lord, plaint also, your lordship will find the schedule out of the scheduled land, a certain portion of land has been acquired for widening the national highway, my lord, 37, my lord. And the compensation was given to, my lord, defendants, my lord, because they are the owner as well as the possessor of the land. Therefore, they get some compensation, my lord. Now, the plaintiffs also claiming the part of the compensation which we have received. And in our written statement, we have very categorically stated that it's a national highway has the acquiring authority. So without making the national highway as a party and without, my lord, this cannot be issued, decided. And my lord, my lord, for acquisition and compensation part, my lord, there is a specific court, my lord, that is, my lord, court of the district
What are
judge.
the issues framed by the court? Have you annexed?
Yes, yes, I have annexed, my lord. I have annexed, my lord, page, my lord. Page 47, Annexure 4. Lordship got it? Whether the suit is maintainable in its present form, whether there is any cause of action for the suit, whether the suit is bad for non-gender of necessary parties, whether the plaintiffs have right title and interest along with principal defendants over the suit land, whether the plaintiffs are entitled to preliminary decree for partition of the suit land, fixing the share of the plaintiffs as well as defendants over the suit scheduled land, whether the plaintiffs are entitled to recovery of khas and delivery of vacant possession of proportionate share of the suit scheduled land by removing the man and materials therefrom, whether the names of the plaintiffs are required to be restored by the revenue authority, whether the plaintiffs are entitled to the compensation, this is entitled to the compensation for the acquisition of the part of the Schedule D and E plot of land, thereby entitled to recover proportionate monetary compensation from the defendant number 1, 2, 3, and 4. To what reliefs the plaintiffs are entitled to. So, my lord, the so, my lord, whether that property was orally partitioned
Now, see,
or not.
Your case. Now see
Yes.
the issue number 5, which is framed by the court already.
Issue number?
It will issue number 5, the court already framed. It covers that whether the plaintiffs are entitled for preliminary decree for partition of the suit, which covers your oral. This one also, it will cover this suit orally partition. Everything will be covered by the test issues. So now these are the questions that have been decided, and then now this that issue number 8 also, it will cover your other aspect of the case, educated dispute related entitlement, proportional compensation. That is already there, in fact.
No, my lord, when my
It
lord,
is already there now. Part by limitation is an issue where it is taken up in a casual manner in every WS it has been case. And whether your case is purely only based on WS, I mean, part by limitation is different thing. Whether you have on that aspect, whether you have submitted anything in that regard regarding the limitation.
Yes, my lord.
In your WS.
Yes, my lord. We have categorically
But other
stated, my
this,
lord.
this your
Well, at
this
least,
item
my lord,
number
the court
J,
ought
I,
to
these are
have,
the issues are already covered by the court, in fact.
my lord, what order 14 rule 5 says, my lord, the additional issues can be
No, that
framed
is here. I'm
at any
saying
time.
that now
Yes,
the court has ample power also to
yes,
decide or frame any issues at the time of writing, even the judgment also,
yes,
if it found necessary.
yes, but
No, I'm saying what I'm saying that your your page 13 in your 5,
yes,
J, I, whatever you have said, these two aspects have already been covered by the two issues has already been framed by number 5 and 8 by the court
no, but
itself.
my lord, whether the suit properties are still available for partition or not, because land has already been
That's why
acquired,
that's
my
what
lord.
I'm saying, that your petition entitled for preliminary decree, that is the issue where everything will be covered, whether the oral partition is there, whether still in existence, everything will be there. In item issue number 5, it will be covered up by issue number 5, and 8 will also cover regarding the competition matters.
No, but my lord,
You
at
see,
least, my
it's
lord, the
there.
court could have, because, my lord, after, my lord, considerable period of
So what
time,
is the now? What is the stage of the case at present?
the evidence stays, my lord. And the petitioner, my lord, in the event of framing these additional issues, my lord, 2-3 additional issues, my lord, they will get opportunity to let their evidence. Suppose, my lord,
Okay,
the
then,
court
but the-
proceed and thereafter, my lord, the
But now
court has.
see, you have filed your petition claiming at least as many as 12 numbers of
That
issues.
is there, my lord.
Why
But
didn't
my
you
lord,
file a fresh
but
petition?
my lord, I am, my lord, very limited on this particular, my lord, 1, 2, 3, and 4, my lord. This, my lord, 4 I am relying on, my lord. I am not on the 12, my lord, petition which they have filed, my lord. My lord, page
You have filed.
13. my
filed.
lord.
You have filed.
We have filed, my lord.
Uh-huh.
We have filed. So my humble prayer, my lord, at least, my lord, notice may go, and my lord, the further proceeding may be stayed, and my lord, they are not prejudiced, my lord. If, my lord, the whether suit properties are still available for partition and barred by limitation, my lord, and orally partition, my lord, these three were, my lord, framed, they will,
But they
plaintiffs
have
also
also
get.
prayed for recovery of cash position, and that means position is with you now. That may cause, if it is delayed, then it may cause prejudice to them also.
No, my lord, but at this stage, my lord, at this stage, the case is fixed for, my lord, evidence, my lord. Their evidence is not over. Only they have submitted their evidence in the form of affidavit. And on the last date, my lord, they pray for filing of the other witnesses, and the court, my lord, last date was fixed on 2012, and court has fixed the next date, 28/1/2026.
28?
28/1/2026 for evidence of further PWs. So at this stage, my lord, if the additional issues
Process not yet started.
process not yet started, my lord. So no prejudice will be caused to the plaintiffs, my lord. And my lord, suppose, my lord, after 4-5 years, my lord, some new issues were, my lord, which we have suggested that were framed. In that event, my lord, again there will be a question of examination of witnesses and all, my lord. So considering these aspects, my lord, at least notice may go.
The petition under 27 first challenging the order, implement order dated 3/11 passed by the Court of Ranesi, which has senior division Kodakat in Package 6 2022, whereby prayer filed by the present petitioners under order 14 Rule 5 CPC for framing additional issues were rejected by the Cabinet. Issue notice to all the respondents, respondents to speed post and agitated post. Further, it is submitted by Mr. Doctor that the two PWs have already filed their evidence, affidavit of evidence, and cases at the stage of evidence. However, case of evidence, stage of evidence of PWs post. He further submitted that there are some important issues which were not considered by the learned trial court below at the time of framing the issues, and also rejected the prayer for framing of additional issues which may cause prejudice to the present petitioner, and in the same time it will also not cause any prejudice to the other side. Accordingly, it is submitted that till the next returnable date, the further proceeding in title suit number
6 of
6/2022 may be stayed. considering this submission by the consideration other aspects of the case. Further proceeding in case number so and so state till next state. This after 4 weeks as an entity by the registry. Further endeavor shall be made to dispose of the matter on the next days.
I'm deeply obliged.
May I have your lordship? My lord, the present petitioners filed a title suit before the learned Munshif at Borpeta. Kindly see page 16. Here, Shodev Das and Joydev Das. These are the principal plaintiffs. They filed the suit against Lakshman Das, Amal Das, etc. Now, during the pendency of the title suit, the plaintiff number 2, Joydev Das, died. Kindly see page 102. Date of death 23/8/2013. And the decree of the learned court was passed, decree and judgment and decree was passed. Kindly see now page 72. That is, the judgment day was 9/1/2025. So the judgment has been passed after nearly 13 years later of the death of Joydev Das. Joydev Das, who died on 23/8/2013, and the present petitioner number 2, 2A, 2A, 2B, 2C, 2D, page 2. These are the legal heirs of late Joydev Das. But they were not substituted as the party in the title suit by the defendant, though this was informed to them.
By the
So,
defendant.
my lord,
You were originally you were the plaintiff.
I am the plaintiff.
A suit is decreed in your favor.
No, the suit was dismissed. Suit was dismissed and decree was executed after 13 years, after 17 years. The 7 plus 5, that is 12 and some months. So,
Have you given any information?
yes, information we have given.
So who is whose duty?
And we have given information, not only this, we are close door neighbors.
You were the plaintiff.
Yes, I am the plaintiff.
So whose duty was there?
It is our
Substitute.
It is our duty to inform them, but it is their duty to substitute the legal heirs of Joydev Das.
Why? Why?
Because, my lord, they want.
You were the plaintiff. They were the defendant.
Yes.
Your plaintiff died. So
Yes.
who will going to substitute?
No, because, my lord,
Defendant will substitute.
because
Suppose if information is with the
there was
defendant, it is the
counterclaim.
duty of the defendant to inform the court.
No,
that
my,
what
let
died.
me submit, my lord. They have claimed, they have filed a counterclaim. So when they have counterclaim against Joydev Das also, so Joydev Das's legal heirs should have been implemented, substituted.
Okay, it is for the counterclaim, and it
Yes.
is for you.
And our duty is to inform. Our duty is to inform. My lord.
Your counterclaim, their duty was to implement.
Yes.
And your duty was not there in the.
No, our duty was there. Our duty we have performed. We have performed our
Your
duty.
plane you have in your plane you have substituted.
No, we
Your
have not
plaint you have
substituted.
substituted.
We have said that as Joydev Das has died,
Ah.
so these are the legal heirs. So you may substitute them as the legal as
The legal price in the counterclaim.
Yes.
Okay.
Yes.
Now, what is your duty?
My duty, my lord, that lordship may kindly say.
No, you have substituted your plaint.
Kindly say, my lord, pass order 23, rule 10A. Here, duty of the pleader to communicate to the court death of a party. Whenever a pleader appearing for a party, to the suit comes to know of the death of that party, he shall inform the court about it, and the court shall thereupon give notice to such death to the other party, and for this purpose, the contract between the pleader and the deceased party shall be deemed to subsist. So our duty was to inform the court. Here, court was informed or not, I have no idea, but party was informed. So substantial compliance is there. So, and moreover, both the parties are of the close door neighbors, and kindly see their address.
No, my question is that he died in 2013.
13.
Suit was filed in 2012. So
Yes.
let it be after 1 or 1.5 years he died.
Yes.
Isn't it? So, but decree in the counterclaim, what they did counterclaim,
In
they got the
25.
decree in 25.
Yes.
Isn't it? So what is your, it was not your duty also. to
My duty-
substitute your plate.
No, my duty.
Substituting the legal heirs of the plaintiff number 2, it was your duty also.
No, my duty, I have substantial compliance. I have, because I have informed the party.
What is substantial compliance what you have done?
So
Have you filed any petition? Have you insisted your the court?
no,
with the party,
that may be seen, of course.
whether it was informed within the limitation,
That
within the
was that
statutory
may,
hearing?
my lord, that may be seen in record,
Ah.
but here I have no proof. But I have made categorical statement that we have informed the party that so and so person has.
Why your plaint was not substituted? Plaintiff number, legal heirs of the plaintiff number 2,
Yes,
plaintiff
yes.
number 2 died.
No, that was not
So-
done.
So why you have not substituted?
I have not substituted. That was my mistake, because that was my mistake.
Oh,
But
that was your
when-
mistake.
But that was my mistake, because I should have been substituted them as legal party, that instead of this Joydev Das, so the legal heirs,
Ah.
they should be implemented as the plaintiff number A to D
Yes.
or 1 to 4. So that was not done. But when they have made the counterclaim, my question is this: they should have, because their counterclaim has been decreed. Their counterclaim has been decreed. So they did not.
So why have come with this petition? What is your prayer now here?
Now my prayer is this, my lord.
Yes.
So when that lordship may kindly say pass.
Your
Uh,
prayer is that the
verse
against the
13.
dead person, the decree was there.
Yes, against the
Oh.
dead person.
Acha.
And law is very much clear, my lord.
Yes.
For a moment, kindly see.
Okay, we're issuing notice only. That part we cannot do
Order to,
anything here.
one order of our court is there, my lord. If your lordship is satisfied.
See, here the position is a bit different. It is not a case of that only counterclaim has to be substituted the legal heirs of the plaintiff. It is
Yes.
your duty. to
Both sides
substitute
duty.
your-
It is both
your
sides
complaint,
duty.
Because case is filed by you only.
Yes, I understand
It was
that.
not known to you whether it was it will be decreed
My lord,
in your favor or
whether it
in
is
favor of the defendant.
whether
So
it is done or not, it
Now
may
see,
be.
it is the case filed by you only. You were the plaintiff.
Yes.
You were the plaintiff, so you are seeking any relief. You are
Yes,
seeking
that
a
that was
decree.
done or not,
And they
on
made a
record we do not
counterclaim.
find.
Fortunately, unfortunately, whatever they got the decree in counterclaim.
Yes.
So now how you have come?
And against that counterclaim, we have also filed WS. Now, my lord, my
You have
submission is
filed your
this.
WS.
My submission is this. Here in this case, the rule 22, sub rule 4
Yes, rule is there already. Okay.
says that degree is nullity. So, my lord, if lordship issuing notice, but at the same time, one pair, my lord, let the records be called for. Otherwise, record will say whether what parties done what things in the court below. So it is a all case, so we could not collect everything.
Section 115 CPC, read with Article 227 of the Constitution of India. You are against. Against the decree passed in the counterclaim filed by the respondents in connection with TS T04 of the 2012. It is submitted that during the pendency of the said suit, the plaintiff number 2 died in 23/8/2023, but without impleting the legal heirs of the deceased plaintiff as a party, the decree was passed on 9/1/2025, which is a nullity. Issue notice to all the respondents through speed post. And also you want to call for a case.
Yes, yes. Otherwise, my lord, it may not be
The
proper
case
to
record
understand the
is
matter.
304 of Lictor. And
From
is
the
the
court
matter
of London
in
Munshif at Borpet.
London Munchi Portal. It is the matter of 4 weeks as an addendum.
There is one order of our High Court is that it has been said that you file a review petition there. So if your lordship may desire, you may see
who filed
when a decree against a dead person is
that is already there.
Yes.
A decree against a dead person is a nullity. It is,
Yes,
it is accepted. It is
yes.
not there, but your cases are big.
Page 92 is rejection order.
92.
Yes, ma'am. Main ground is my lord ground of arrest or not servicing. In this ground, your lordship.
Earlier, you have not taken the count of arrest.
I have taken, but your lordship's rejected.
Acha.
But now, recent judgment of Supreme Court, my lord, Mihir Rajesh Shah, that is mandatory, my lordships. Page 90 from page 96, my lord. Page 96.
96 of
Yeah.
whose order?
Yes, my lord. Your
You
rejection.
have annexed here.
Yes, yes, my lord.
Acha, 96.
96.
Acha. Yes.
Para 16. It is a fact that the accused was behind the bar for more than 8 months until that prosecution has not examined any of the witness out of 50 cited witnesses, and it is also an admitted fact that while issuing the notice under 50 CRPC as well as in the arrest memo, there is no detailed description of the grounds of arrest, but the name of the accused and other particulars of the case are mentioned in the ground of arrest, and the signature of the accused is also available in the notice issued to him under section 50 CRPC as well as in the arrest memo. Your lordship rejected on ground para 20. Further, considering the observation made by the Honorable Supreme Court in the case of C. Darshan, it is seen that there may not be any ground of arrest in case of person arrested on warrant, and it is seen that it is also observed by the Honorable Apex Court in Darshan as referred above. The substantial complaints may serve the purpose of communication of the ground of arrest, and in the present case, it is seen that he was fully aware about the ground of arrest which was communicated to him. On that ground, your lordship rejected. But now, Honorable Supreme Court in later on, Mihir Rajesh Shah, Ishan Gav.
Which para? Basically, you relay.
Para 56, page 52. Page 52, maybe. I have marked. In conclusion, it is held that the constitutional mandate of informing the arrestee the ground of arrest is mandatory in all offences under all statutes, including offences under IPC 1860. The ground of arrest must be communicated in writing to the arrestee in the language he understands. In cases where the arresting officer person is unable to communicate the ground of arrest in writing or soon after arrest, it is to be done orally. The said grounds be communicated in writing within a reasonable time, and in any case, at least 2 hours prior to production of the arrestee for remand proceeding before the magistrate. In case of non-compliance of the above, the arrest and subsequent remand would be rendered illegal and the person will be at liberty to be set free. That is latest judgment. My basic, my lord, submission is that, my lord, ground of arrest not furnished to me, my lord. But in Mihir Rajesh Shah, my lord, the Honorable Supreme Court clearly specified the ground of arrest in writing should be given. Page 69 is, my lord, under section 50 CRPC, ground of, my lord, serve on me, but ground of arrest not mentioned.
Para 58 says.
Yes, my lord. Yes, para 58, my lord. We are cognizant that there existed no consistent or binding requirement mandating written commission of the grounds of arrest for all the offences. Holding as above in our view would ensure implementation of the constitutional rights provided to an arrestee as engrafted under Article 22 of the Constitution of India is in an effective manner. Such clarity on obligation would avoid uncertainty in the administration of criminal justice. The ends of fairness and legal discipline therefore demand that procedure as affirmed above all govern arrestee henceforth. Yeah. Yes.
Yeah, yes. Any other subject?
Yes, my lord. In this regard, my lord, our Honorable High Court also discussed and granted bail, but in Sangita, Para 33, my lord. May I read, my lord? Now coming to the submission made by the learned additional PP, Assam and his reliance on the case of Darshan, etc. Supra, this court is of the opinion that the Honorable Apex Court, by its judicial pronouncement made in the case of Mihir Rajesh Shah, clarified that the grounds of arrest must be communicated in writing to the arrestee. Otherwise, the arrest is in violation of the statutory provision contained in the CRPC. The case also clarified that the grounds of arrest must be communicated in writing within a reasonable time and in any case at least 2 hours prior to production of the arrestee for remand proceeding before the magistrate. Therefore, the argument that has been forwarded by the learned additional PP assumes that no prejudice has been caused to the accused applicant since she was intimated about the grounds of arrest will not have any sustainable value or force. That is my case, my lord. Recent, my lord, in this Mihir Rajesh Shah discussed in this Sangita Datta bail cases, my lord, and granted bail, my lord. And out of 52 witnesses, only 3 examined. This prolonged incarceration, my lord, that is, my lord, one ground, my lord.
Till now, what is your time period?
Yes, my lord.
While passing the earlier order, it was 8 months now.
Yes, now petitioner number 1 is 12 months and petitioner number 2 is 10 months. In Sangita Datta case, my lord, prolonged incarceration also, my lord, discussed in this. This is my submission. That, my lord, recent judgment of Supreme Court, my lord, that is mandatory. Written, my lord, ground should be communicated to the petition accused and his relatives. In all cases, my lord.
This is the said murder case in Dipu.
Yes, yes.
Lordship, otherwise, out of 52 listed witnesses, 3 witnesses has been examined, including 2 eyewitnesses, Lordship, and 1 Caesar witness. And
3 eyewitnesses.
2 eyewitnesses and 1 Caesar witness. And so far as Lordship, State of Karnataka versus Darshan is very clearly states that while considering the bail, the VT evidence and the gravity of the offense has to be considered by the court, as well as Lordship procedure lapse in furnishing written grounds of arrest without demonstrable prejudice do not automatically justify a bail application.
What? What's happening?
Lordship, procedure lapse in furnishing grounds of arrest without demonstrable prejudice do not automatically justify the bail application. That is very clearly stated by the Supreme Court in state of Karnataka versus Dixon. And Lordship, so far as notice under section 50 and 50A of CRPC is concerned, that has been duly served upon the relatives as well as the accused also, that I have flag mark. And ground of arrest and arrest memo also give enough, Lordship. It is well informed that he has been arrested under section so and so. Nothing is required. It's duly complied with, Lordship, section 50 and 50A of the CRPC. So it cannot be a ground for rejecting the bail application. Otherwise, on merit also, there are sufficient grounds to reject the bail application of the earlier. This is third bail application. It has been rejected twice earlier.
During that time, my lord, Mihir Bajaj Shah was not discussed, my lord. This is later, my lord. Torsion was discussed, my lord. During this time, my lord, that was law, my lord. But in Mihir Bajaj Shah, my lord, Mihir Rajesh Shah, my lord, it is clearly stated that.
In fact, Lordship, same proposition is reiterated here.
Oh, my lord, here is specifically
same
discussed.
propositions.
Specifically discussed.
Which is also discussed in state of Karnataka versus Darshan.
Yes, my lord, that was also discussed in Mihir Rajesh Shah, my lord. But bail was granted to the appellant. And my lord, Sangita Datta, yes. Sangita Datta case also, my lord, discussed Darshan case, my lord. But that is denied, my lord.
So that's why I'll just pressing the para 58.
Yes, Doctor.
Now, para 58 here, we are cognizant that there existed no consistent or binding requirement.
Yes.
Mandating the written communication in the grounds of arrest for all offences.
Yes.
Holding as in our view, would ensure implementation of the constitutional rights provided to an arrestee. That has to be complied with. The constitutional rights which were provided to an arrestee has to be complied with. If you read by the 58, it says something. Anyway, see to it.
Yes, my lord. My lord, 60, my lord.
Yes, 60.
Yes, 60. As far the criminal appeal so and so and criminal appeal is concerned, this court, while granting leave on so and so, had by way of ad interim relief, directed the appellants to be released on bail during pendency of these appeals. The same shall continue. However, the prosecution may move an application for remand or custody if required, along with the reasons and necessity for the same. After the supply of the ground of arrest in writing to the accused before the magistrate, if the case has not been committed for trial, in the case that trial having commenced before the trial court as the case. Yes, there is observation.
Anyway,
and my lord, prolonged interrogation also, my lord, discussed in my lord in Sangita Datta case, my lord. It is my lord.
Yeah, obviously, prolonged incarceration may be one kind of
trial proceeding.
That is number of.
Obviously, speedy trial, even if suppose order is there, 52 witness examination is not a matter of.
Yes, otherwise it's a
great
great offense against the young lady. She has been brutally killed. She has been gunned down, Lordship.
Yes. Gun. Okay, I'll pass you.
Obliged.
May it please, Lordship.
Yes.
Lordship, this appeal is against the decree dated 21 January 2025. My lord, the fact of the case is that the appellant, her husband and the plaintiff, they have jointly inherited a plot of land. And the claim of the plaintiff was that her mother and the husband of the present appellant,
they have executed a sale deed in her favor in respect of their share in the ancestral property, and thereby the plaintiff has become the absolute owner of the property they have jointly inherited. Now, based on that, as we are claiming right over the property, she filed a suit saying that the husband of the present appellant and her mother-in-law has already transferred the property to the plaintiff, who is the daughter of the. So she is the absolute owner. Lordship will get the order at page 81, impugned order, judgment, I mean. My lord, kindly turn to page number 83, paragraph 2 will cleanse the facts as narrated, my lord. It was an 83 relevant. Judgment starts at 81.
Yes.
My lord, paragraph number 2. May I read it, my lord? For clarity of the facts, my lord. The case of the plaintiff is that the father of the plaintiff, late Taranikaanta Das, purchased the scheduled land from one so-and-so in the year 1990. The plaintiff's father died on 27/3/2011, and after his death, the plaintiff, along with her mother, late Minu Das, and her brother, late Kaushik Das. My lord, this Kaushik Das is the deceased husband of the present appellant, became the absolute owner and possessor of the scheduled land as legal heirs of the deceased father. Accordingly, filed order at the so-and-so circle officer, dispute revenue circle, mutated the name of the plaintiff along with her mother and brother has been mutated in the revenue records. The plaintiff has stated that her mother and brother had sold their 2/3 portion of the scheduled land to the plaintiff at a total consideration of rupees such and such by registered sale deed number so-and-so. And since then, the plaintiff has been occupying the said land peacefully by paying land revenue, and the same has been mutated in the name of the plaintiff. Filed order at a so-and-so. Thereafter, patta numbers of the suit was changed from such and such to such and such. The number was also changed. And this is the fact narrated, my lord, by the plaintiff. The case of the defendant, my lord, defendant could not file her WS on time. It was actually originally declared ex parte. Later on, she filed, but court said she has given the right to cross-examine only. That was not accepted. So, however, there was no such resistance on her part, and finally this order was passed. Well, order passed says that yes, by virtue of this sale deed as 5480 of 2012, by virtue of this sale deed, the plaintiff got absolute ownership over the suit land. Operative part of this, your lordship will find at page number 89. Rather 90 will clear, my lord. 89, last paragraph. Considering the above material on record, it appears that the evidence adduced by the plaintiff would show that scheduled land is no longer a joint family property of the parties, but the same is self-acquired property of the plaintiff. As such, plaintiff has adduced sufficient so-and-so, and it was decreed in favor of the plaintiff. My lord, kindly, I have enclosed this document.
I mean self-acquired, how self-acquired?
Because, my lord, it was inherited by the plaintiff, her mother and brother. Mother and brother are now not there. So they have executed a sale deed as this sale deed number 5480 of 2012. Their portion, 2/3 of the property, she says that it was transferred to her. I have annexed the sale deed. Lordship will kindly turn to page number 31 of my appeal. This is the sale deed she exhibited. A mere reading of the sale deed, my lord, will show this is not a deed of conveyance at all. This is not a sale deed. My lord, that is my submission before your lordship, my lord. At page 31, lordship will get it. Kindly turn to, my lord, page number 33 is the parties, Minu Das and Kaushik Das. There the Antonia Seth is the plaintiff. Lordship will kindly turn to page number 34. I'll read some of the portion of this sale deed, my lord. Page number 34, my lord, third paragraph.
In original case, you are the defendant.
Yes. Well, third paragraph I will be reading. And whereas the vendors, having found the offer of the purchaser to be just and fair, agreed to sell and convey to them at offer price of rupees 11,20,000 only, being the actual consideration money for the land measuring 2.14 r covered by Doug number such and such, such and such, such and such. And whereas the government valuation of the aforesaid land being assessed at rupees 11,20,000 only by the office of the Deputy Commissioner Kamrup Metro, and the statutory fees and charges are being paid on the basis of the government valuation specifically mentioned in the sale permission dated so and so, so and so, so and so. My lord, both this paragraph clearly says this is not a sale deed, but this was merely an agreement, and the government valuation has been paid on this 11,20,000. But there is no mention that she has paid the value consideration amount to the purchaser. I'll read it again, my lord. At page 34, last paragraph. And whereas the government valuation of the aforesaid land being assessed at 11,20,000 only by the office of the Deputy Commissioner Kamrup Metro, and the statutory fees and charges are being paid on the basis of the government valuation specifically mentioned in the sale permission number so and so issued under signature of CEO GMDA. Thereafter, my lord, terms and condition, now this says, as agreed upon between the parties, the consideration of rupees 11,20,000 only for the purpose of registration and statutory fees and charges are being paid on the basis of the government valuation specifically mentioned in the sale permission number so and so. That for the point number 2, for consideration agreed by and between the parties to these presents, the vendors hereby agree to grant, sell, convey, and transfer, assign, and assure upon the vendee so and so. It's a long paragraph. It says he agrees to convey the property. Then, my lord, paragraph number 4 down below on page 36, that the vendors and all persons claiming under it do hereby further agree with the purchaser at all times hereinafter, and upon any reasonable request to execute or cause to be done or executed all such lawful acts, deeds, and things whatsoever. Then lordship will kindly skip paragraph 5 and come to paragraph number 6, that the vendors declare and admit that the actual and physical possession of the said property shall be handed over to the purchaser at the time of execution of the sale deed, and all the original titles and said property shall also be handed over to on completion of the sale deed mentioned supra. This is how this sale deed proceeds, my lord. Nowhere there has been said that I have conveyed the title or ownership upon her. There is no statement that the consideration amount was also paid. Only it's a mere agreement between the parties. But based on this document, my lord, the title has been declared in favor of the plaintiff, my lord. Simply paying the, my lord, registration fees and whatever government fees is required will not make a document sale deed, my lord. It has to be properly mentioned that I am transferring this thing. Everything is the nature of an agreement only between those two deceased person and the plaintiff. And when the defendant here, the appellant claimed, then the suit was proceeded that way, my lord. And finally, it was decreed on the basis of this document. So, my lord, this there is a ground for intervention by this honorable court, my lord. I have also filed a miscase praying for stay of the operation of this impugned order.
Kaushik Das, he died.
Yes, he died. He is the husband of the present appellant. He has his wife and a minor daughter now studying in his class 11.
And what about the mother of your
Mother also expired in the meantime. Minu Das also expired.
So now what is yours then? You have not sold your property to your sister and all? No.
No, my lord. It was not sold. We have not received any money consideration. But my lord, in the suit, there was no WS also filed. A considerable WS filed, my lord, on time. But my lord, whatever be the situation, my lord, when a decree is passed on the based on the document, my lord, if that document per se is defective, plaintiff has to prove her case by adducing valid documents, my lord. That has this document what she exhibited and said this was the registered deed. This is
It
not a
was
self.
exhibited, this mutation order, sale deeds.
Yes, my lord.
copy deeds,
Pursuant
those
to
were
that,
exhibited.
no mutation order exhibited. She exhibited this sale deed, and this was considered while granting her title. When the sale deed itself is defective, my lord, it is not a sale deed. It's actually this is a sale agreement. This cannot transfer title from one person to others. That's how the, my lord, the judgment in my humble submission is. This document, my lord, based on which the judgment passed cannot. There is IA under 41(5), my lord. IA number 4180.
It is within time or what?
My lord, it was filed within time, my lord. But what happened there, it was filed defective because the court fee that was to be paid, my lord. She is a widow, she could not arrange, my lord. That 11,000 court fee was required to be paid. And thereby, my lord, though it was filed on time, it was listed late, my lord.
So now it is time-barred, or is there
No, nothing like that, my lord. It was filed on time. Filed on time. Only the court
Is
fee
there
was
any
paid
note
late.
from
And
the section? No.
no, my lord.
And
That will not come in, my lord. Yes, section is cleared, my lord.
section has cleared.
Yes, my lord. That's why it is on list. My lord, there is a note, there is no delay, some kind of notice there on the top. That's will find, my lord. দেখুন চেক লিস্ট বানাতে পাবো
Mr. Sharma.
Yes, ma'am. And PR, sir.
Mr. P.R. Sharma, done it. It's an appeal under 41. Rule 1 CPC against the judgment and order decree dated 2101 by Learned Civil Justice Senior Division, Learned Civil Justice Senior Division number 3, Kamrupan, in that 19 of the whereby suit is decreed in favor of the respondent. Considering this action made by and is admitted, issue notice to the respondents to speed post and as usual post for the PC list. I had to click Mr. Sharma with an applicant. Next is an applicant. One CPC to stay of judgment and decree dated 2101/2025 passed by Learned Civil Justice Senior Division number 3 Amur M in brackets 19 of is submitted by Mr. Sharma that the decree was passed on the basis of this document, which is cannot be considered as a sale deed, and it was merely in sale agreement. However, as the case proceeded ex parte, the present applicant of the appellant could not take stand against WS. Further submitted that if the execution is proceeded, present petitioner will be, the prejudice will be caused to the present applicant. Accordingly, for stay, the execution of the judgment and decree dated 21/01. Considering the sufficient date, the execution of order, judgment and order dated 21/01/2025 is stay till disposal of connected RFA 80 of BTA of observation, the present highest.
I'm deeply obliged, my lord.
Right. Another decision appeal against the judgment and decree dated 2017-2025. Page 21. The appellant has filed a petition under Section 9 of Hindu Marriage Act for restitution of conjugal right.
Temporary charges and various other charges, my lord. The lordship may issue notice at this stage, my lord, and
Yeah, you're appearing here?
Yes, appearing for the
records will be called for my lord.
You're representing respondent numbers?
Yes, all respondents.
All respondents. Oh, only one respondent, Union of India.
Yes,
much. You are Mr. Rathi or?
Yes, my lord.
Rathi. Part Mr. D. Rathi, the learned counsel for the appellate. Also part Mr.
I'm at the beach.
Hana R.K. Chotu. You are appearing as a deputy SGA?
Yes.
DSGA?
Yes.
DSGA for the respondent of the Union of India. This is an appeal under Section 23 of the Railway Claims Tribunal Act 1987 against the judgment and order dated 20/08/2025 passed in original application number OA Roman 3 Big Roman 3 G85/11/2024 court of Railway Claims Tribunal Guwahati. Issue notice to the respondents as Mr. Chaudhary, the learned DSGI has already no formal notice is required to be served on the respondent. A copy of the appeal may be served during the course. When it will be listed after 4 weeks will do, you need some time.
My lord, if any date may be fixed, any date.
It will be in the first week of February.
My lord, first week.
It will be admitted. The matter will be listed. 5th of 5th of February.
My lord, I am having personal difficulty. I'll be out of station on 5th of February. Can it be taken up on 11th of February, 10th of February?
It will do?
Yes.
10th of. Okay, we're listing it on 10th of February.
My lord. If it can be fixed on hearing, my lord, and lower court record may be called for by LCR.
We'll call for the case recorder. TCR we call for. In hearing column, you want to fix it?
My lord, if
There's
it,
no for admission.
Admission.
it is listed for admission today only, my
The
lord.
matter. Let it be on hearing column. Let me see.
Yes, my lord. It can only question of law is this.
Yes.
My lord, I have similar prayer in respect to item number 24 to 29. Railway appeal only.
the matters, Lordship, my and
You are appearing on 24. Here also only one Union of India is there, or
Yes.
24. Yes, that will do. So she is appearing on 24, huh?
25, my
25 you are appearing.
is appearing.
Namila Global, 25 she is appearing.
Again, 26, Lordship, I am appearing.
Yes. 26 Mr. Chaudhary is appearing. 27.
27, 28. And
27 and 28 who is appearing here?
Lordship may record my name, and 29.
So 26, 27, 28 and 29.
Yes,
we are recording your name.
Lordship.
Same order. Akedi Chaudhary, 26, 27, 28 and 29. And Mr. MSDB and MS, your MSD. Sharma, B. Sharma. They are appearing for 24 and 25. Otherwise, same order, khali or the case number, judgment or date are here to change. Or are appeal. Yes, you are on 24, she is on 24. Ms. Sharma is on 24. Okay, well,
Much obliged.
Yeah, please, Your Lordship. My lord, this honorable court has called for the scanned copy of the records of the mistakes which has been received by this honorable court.
we have received, I think, already.
Yes, my lord. That has been received, my lord. Let me fix, my lord, for hearing on this petition.
Lordship, I am appearing for the sole respondent.
Sole
Here-
respondent.
Here the matter is regarding disconnection of electricity.
No, my lord, this is not the matter.
Let me come. Let me submit. Matter was regarding disconnection of suit was regarding electricity. Interim injunction was passed, made absolute. Thereafter, they have disconnect. Court, as a measure, a temporary measure, directed ACB to give a temporary connection. It is on the record in the order sheet that they obstructed. Their brother, who is one of the co-landlord, he says he has done it. He is one of the landlord. His brother, his mother, they are also there. They say he has done it. Police report has come that they have done it. And I am without electricity for last more than 3.5 months. In spite of court order, in my 151 petition to give direction to the ACB to give me line, till it is restored because they have not restored. Now in this matter they have come in revision because the court fixed that matter for order. They have come because their two petitions were rejected. In this 151 petition, they filed a petition to examine one person who is not the deponent. Order 19 rule 2, only deponent can be examined. Deponent, he is not the deponent. Husband is the deponent. They have not filed petition. His wife, who has filed power of attorney as document number 1, evidence completed, it is for final argument, the suit. In that case, wife says that all my matters are looked after by my husband all along till from filing of the suit. Husband is representing in the case. Now they want to wife to be cross-examined. Second petition, they want at this argument stage in this case, they want my return to be filed, affecting my right to privacy. They will not prove anything. They will want me to produce the document. Court says it is simply a police help matter for implementing, affecting an order passed by this court. Against that they have. So my humble submission is okay, it may be taken day after tomorrow. This is urgency. I am 3 months, I am without electricity.
My lord.
And it is a commercial shop.
Okay, but I am the petitioner. Let me submit first. This is, I have not challenged the order by which the electric line has been directed, by which the petitioner is directed to avail of the electricity. Already they have applied, they have availed of. That is not the subject matter of this case. Subject matter of this case is this way, my lord. I have filed 2 applications. They have sublet the premises, and I have enclosed relevant documents, which is also on the record. That is at page 38. I have let out the premises to the respondent, not to the subtenant. That's why when I came to know that they have sublet the premises to one of the subtenants, simply I have filed 2 applications that the subtenant petitioner may be directed to produce the documents of the partnership deed. They have shown that there is a partnership deed and some income tax return by which to whom he is paying the rent. That was only for examination of the
No,
document.
yes, the question is
that-
that you
that
have
was only
filed two
that.
petitions, which are
I took-
now,
So-
as per you, the electricity connection, etc.
No,
is
I have not
in
challenged that
connection with
order.
this case.
No, I
So
have
why
not
don't
challenged-
you file a petition
Yes,
before-
ma'am. Those two petitions, if it is heard, but tomorrow matter is fixed for that on
Is
my.
there any order on stay?
No, there is no order of stay from
no
this court.
order
On
of
the
stay.
last date when the matter came before this court and call for the record, court say we are not passing any stay order. You go and proceed. So here it may be made clear this pendency of this will not debar the court from proceeding with that. Let them in the suit because you're not subletting. Whose burden is this? His burden.
No,
and he
my-
already filed a separate
My lord,
suit for it.
my lord.
Let
They
me
have
let me
not,
submit.
no,
He has already filed a
my lord.
separate ejectment suit.
My-
That is in argument stage. In that case, he has taken subletting point. It is to be decided in that why this suit is only for electricity and nothing else.
My lord, I have
No,
not
but
challenged that
this
order.
CRP is for only for electricity.
Yes. No, they have come CRP because their two petition was rejected. Court said in this matter when the restoration of electricity is concerned, all these reports are here. Police has reported. ASCB has reported that they have not disconnected. And when they went to when they went to reconnect the line, it is on the last impugn order. When they went to reconnect, he
You could
objected.
have taken any police help and all.
Then for police now how the court will give order tomorrow is fixed. Tomorrow is the date fixed. If it is this order petition is here, the court will. I don't think they will proceed. So it is made clear that it is not a they may proceed as per law.
No,
That may be made
no,
clear.
my lord,
Because
no.
filing this petition is only to disturb my getting electric connection. ASCB has reported he has obstructed, not allowed them to reach. Police has reported that they have not allowed. He's one of the landlord, his co-owner. He says he was objecting reconnection. He has disconnected. All these things are on the record.
Okay, let me submit, my lord. I have your lordship may come at page 60. The application filed by them, your honor. That is their application, your honor. Now your lordship may come at page 28, where is the prayer portion. What prayer they have sought from the court? I am reading the prayer portion of their application by which they have asked that there is no electric connections. In that petition, they have not made any allegation that the landlord has disconnected the electric connections. They have stated that there is some problem. Let me say.
I'm not
There is some problem in the connection. That's why they file application by making the prayer. You will see, I'm praying. That is most important at page number 27. Under the premises, as aforesaid, your honor may be pleased to call for the records. Consider the petition. Direct the officer in charge of the station, Shri Anil Kumar Bhatra, the opposite party of 1-3. I am opposite party number 1-2. To restore electricity to the Trinity place, thereby ensuring strict compliance of the addendum in this order dated so and so, passed by the land court, so and so, which was made absolute so and so, and or be further pleased to direct the opposite party number 2 and 3, that is the APDCL, to give temporary electric connections to the petitioner at her cost. And that is allowed. Prayer is allowed. So I have not come against that order. Now tomorrow is the date fixed for passing an order on their application by which they have alleged that they want police help. Though there is no application from the APDCL that who has restrained. I have never restrained. I have also present there. I have never.
We have not restrained.
I have not
restrained. APDCL, then let them connection with them.
No. They have already
one
availed of.
Huh?
They have already availed of. My court has allowed the
But
electric
he is
connection.
saying that without any electricity, he is taking.
No, so they have filed an application for police help before that trial court. So the trial court will decide whether police help can be given or not. I am not against that order. I am come against the rejection of my petition. So your lordship may also decide whether the rejection of my petition is in accordance with the law or no. They have not filed any objection against my application by which I wanted to call for certain documents from the petitioner. I want to examine. They have not filed any objection, Your Honor. On the same date on which I have filed my petition, that was rejected. So that is a subject matter. Court trial will decide regarding electric connection. Tomorrow is the
Okay,
date.
then if,
Of that,
if any observation is made, but tomorrow is the date fixed for order only.
for order only.
Your Honor, so if Your Honor, unless you made, Your Honor made it clear that this the deciding of this petition is not a bar of deciding my, it's all right.
There is no stay order, man. There are,
But Your Honor,
There is no stay order.
no
there is
stay
no
order,
stay
but
order.
Your Honor, court say once the petition is pending in the High Court, I am guarantee Your Honor, court will not proceed.
How can he give the guarantee?
No, I am.
He's giving guarantee.
No, Your Honor, there is no stay order. Your Honor, there is no stay order.
That will be decided by the trial court because I have made a prayer. These money, calling all these records are very much necessary in deciding the electric connection. So trial court will decide all tomorrow. How this honorable court has not granted a stay order. There is no bar. Nothing is there. Regarding this two petition only, he has not filed any objection before the trial court against my application. Then why you are insisting? Let my petition, this revision petition may be allowed. Tomorrow court will decide.
If I have not filed any objection, that means
yes.
all petition is court is discussed.
No.
Yeah, when the date matter has been fixed for restoration of electricity by the police, that they filed two petitions. So two petition court has discussed. You know, may kindly see, discussed and rejected.
I can understand that it discussed and tomorrow that two petitions were earlier filed by him is rejected. Now the petition is pending before the learned trial court regarding the police help.
So police have an entire miss case is pending fixed for tomorrow for order.
Yes, tomorrow for order, so order will be passed. I think if
yes,
there is
Your
no
Honor.
day order.
So that's why there is no stay order. I have made prayer, but this honorable court has said that no, I shall not grant any stay order. So court shall decide that petition because that is not the subject matter. I have not challenged that order. I have challenged regarding rejection of
later on, decide later on those two petitions on the admission day. But so far tomorrow is concerned, it may be made clear.
My lord, there are no stay order. Court will proceed in accordance with the law.
The court may proceed. That may be recorded. Because my learned friend has no objection.
When there is no stay order, there is no stay order. At the very stage, this
on the last date also, because this was pending, they have informed their court did not proceed without because did not proceed on the last date also.
But hearing was completed, I think.
Hearing completed. Order, it was fixed for order. On the last day,
order was also passed in their favor. That you can avail of the letter. Already they have availed of.
So he is not
no. He has not made a prayer against me. He has made the prayer for giving direction to the APDCL. And that was allowed by this honorable court.
Obviously, prayer will be for the APDCL only for registration
yes.
electricity.
So they have already availed of. So this petition is only a rejection of my two petition.
So so far these two petitions is concerned, my friend, it may be fixed for admission. But in the meantime, so far that court, it is made clear that there is no. That I want only.
Hard Mr. R.C. Sunset learned counsel for the petition. Also hard Mr. B.K. Jain, learned counsel appearing for the response. Scan copy of the TCL has already been received. Let the matter be listed before admission column. As on it immediately after view, as on a debut before raised. Pardon. As the
if there is any obstruction, I may come again.
If there is further, it is in that there is no stay order passed by this court, and hence there will be no bar for the learned trial court below to pass any order. In which case is pending?
Is this miss case?
Miss case
454.
Yes, ma'am.
Miss J, case number 454 of the 2025. No bar reason pass any order in miss case number so if any. Proceed going.
You know,
the passing date you want.
A date because you know, I know he will not allow it because all the stories like that. He will not allow. His wife will come. His children will come. They will not allow it. No, I am to come again to this.
His wife and children will come, but the question is, it is the duty of your APDCL to restore your.
Yes, but they went there. They could not do because all family member came and they made a law and order problem there. This is reported by the APD. It is
which is not on the record. They are telling you go and give the evidence. My lord, how type he making submission out of the
It
government?
is there on
My
record.
petition is
You
related
can
to
Now
that.
see, as on today, no one can stay without
Yes,
electricity
yes,
connection.
yes,
So
yes, my lord.
whatever
so
your
I have not
petition is
challenged-
rejected or
Ah,
that will be decided by this court as you have filed with CRP.
that's,
The question is restoring of the electricity connection date, court will pass. the order.
yes, yes, that has been passed.
No, that has been passed. You again restrain.
No, I have not, that, for that the order date is fixed for tomorrow. They have.
That's why they have prayed for
So
a
court will decide.
order of prayer for this police help, na? Otherwise, to if
No, the court will decide, your lordship have already
Once
passed the
it
order.
may be had, that may be had. You will make a fix a date. That's
All, a fixed date.
21-1 will do.
You know, can
21,
it be
one.
before this, within
Before
seven-
view.
Before
View.
view.
Not possible.
Then-
May not be possible.
Then even just after view.
Just
21
after
one.
maybe on 19, 20 or 21. That much.
That,
21.
21. Yes. 21, okay. Let it, my lord, 22. 22.
I have no.
22.
Date I will not.
He's making something out of the record. My please, your lordship.
What is in order column?
My lord, already the respondents have been represented and also the TCR has already been received by this honorable court, my lord.
TCR
There is an order, my lord, on 26/9/2025, my lord, for listing of this matter after puja vacation. Might be, that's why this matter has been listed today. 26.
So what was the IF one?
IA for, my lord,
Dispose of it.
IA has
I
been
is already been disposed.
disposed of, my lord. In a main RSA, my lord, there is an order dated 26/9/2025, my lord, whereby this honorable court has directed the registry to list this matter after puja vacation.
Oh,
Can we fix for admission here in your lordship?
My lord,
Admission
matter,
hearing.
my lord, matter has already been admitted.
Admitted.
Admitted, my lord. Admitted.
And you need records here also. Record is needed.
Record is already there, my lord.
Already received.
Already
Okay,
received.
then.
Fix
Then
for
it
hearing.
can be hard, I think.
Yes, yes.
My lord.
If it is already admitted, then
মই admission to বন্ধ।
uh,
মই
Admit will say.
নাই মই
Technical question is law frame will be.
ঠিক আছে হ'ব। মই নাজানো যাম মই চোৱা নাই হ'ব নেকি?
you are Mr.
MK Sharma.
M. K. Sharma. Heard Mr. M. K. Sharma, the learned counsel for the appellate. Also heard Mr. T. Deoli, the learned waiting for the respondent. The TCR has already been received. Matter is already admitted. Stop this the matter accordingly in hearing column. Immediately you want
March-
after you want
February,
any
yes.
fixed date?
February, any fixed date? February.
First week of February?
Yes, sir.
First week
Not
of
first
February.
week of February, my lord, last week of February.
হ'ব,
Possible.
হ'ব।
Last week of February.
My
হ'ব।
Matter will be accordingly listed for hearing in the last week of February as on a date to be fixed by the registry.
Deeply obliged.
Deeply.
May I please, your lordship?
Yes.
Lordship, in this case, before I submitting my submission, similar matter was listed before this Honorable High Court, and order has been passed on 10/12, similar situated case, and fine. And that case is fixed on second week of January. So can it be tagged together?
Lordship, I have objection because they are not similarly situated person. The contention of the last order passed by this honorable court, their contention is clearly different. They have in the last, that is the Om Prakash Gupta case, they have stated that they have Jamamandi in relating to the land in question. They have Jamamandi of 1 katha of land, their name in the land record. That's why that is this honorable court has considered earlier. But regarding these three cases listed today before your lordship, from item number 35, 36, 37, their contention is quite different. They have stated that no survey was done by that is circle officer before before issuing the eviction
So
notice.
as per you, this subject matter is not so
Subject matter but similarly situated person, but contentions are different. Because if they have that is title of her land, definitely I do not have any objection because it will be decided by this honorable court. Because their contention in their petition is only 2 points. That is, the 1 point is no survey has been done by the circle officer. That is completely wrong. Today I have morning received certain copy from ONC record. And number 2 point is that because land is not, that is partition. If they do not have a land in that particular area, because land has been acquired by the ONGC through land acquisition process. We have made the payment and the map has been prepared by the, that is the revenue authority. And moreover, the class of the land has been changed from agriculture to industrial land. We are paying revenue. So their contention in every case is quite different.
Understand, as
Yes.
per you, there may be the contention of the all the petitions may be different.
That's why they are not
Now,
in
but
similar
the-
category.
But the question is that all these petitions are pending before this court today,
Yes, Lord.
only for this condonation of.
Condonation, sir.
In that regard, do you want to
Now,
submit? it?
condemnation will file the objection, definitely.
You're going to file the
File the objection because I have been instructed to file the objection on the part of ONGC.
Then we are
But-
not going to the other aspects of the case. It is because it is not yet, I mean,
Yes,
listed,
Lord.
numbered.
Now,
We also
previously,
didn't see.
without that is the disposing the condemnation petition, that honorable court has, that is giving some observations in their interim prior application. So in that case also, that is we have informed the court that because at that point of time, court has seen only that they are the recorded pot orders, their name in the Jamamundi. But the learned court of District Judge Sibsagar, after considering entire records, calling the entire records, passed the, that is the order, dismiss the appeal. So in 3 cases, they do not have a title of land, nor they have not annexed any documents with the, that is the review application. Lord. So I have objections in the, definitely I will file objection in the, that is the delay of condemnation issue, and other matter also will file the objection. Lord. Because the land is very urgent, we are going to construct a
You're pressing the, that these 3 petitions or the ST's appeals should be disposed of by the tagged with because of one order of stay,
Yes.
the eviction order of stay.
Yes.
But the question is that let the condonation petition be disposed of first.
Yes.
If there is any urgent, then definitely after
Now,
the
urgency in a sense, my lord, I have filed 2 IA here. One is condonation and another is after passing that interim order in the miscase appeal, another eviction notice has been passed. So since it is my fault, I have approached before this honorable court lately, but I have approached before this honorable court earlier on, but that was a wrong forum. It was a writ petition. I have annexed this order. Then it was suggested that it should come
then
under.
in that case there may be a good ground for your
Yes, yes.
allowing your condonation.
Yes, yes.
They want
Yes.
they want to file some
Yes.
revision.
So they may be allowed to file any objection in condonation. But in the meantime, that imminent eviction order may be stayed as has been stayed in this previous order.
That's why I'm saying
For
my
the
view
time
may
being,
be-
for
my view
second,
may
Now,
be
Lordship, before actually disposing the condemnation petition, because their stay may not be considered. Because ONC has not taken coercive measure from since 2022. We are trying to evict them from the, because the land has been duly handed over by the competent revenue authority, that is district administration.
No, on
And
merits,
class of the land has been changed from agricultural to industrial.
See, my this views may be different because I am on the particular view that if it is not yet suppose numbered or registered, interlocutory application should be first disposed of without any interim relief.
My lord.
So in that case, if you want that similar kind of order should be there, so I better suggest that all these petition may be tagged with along with that other petition. But he is saying that
My
it's
lord.
not similarly situated case.
Subject matter may be similar, contentions are completely different.
No, see, contentions may be different. but
Different
if
because
it's
they do not
similarly
have
situated case.
similarly
Similar
situated.
situated. Facts and
Because there is an
circumstances
eviction
may be.
notice in the present cases also, I think, so, but I have not gone
But
through
they do
because
not
of
have a
the
land
time
document.
yesterday.
They
But
do-
the question is that contention of the petitions may be a bit different
Yeah.
to other petition,
Yeah.
but
My lord.
but otherwise similarly situated, I think, because
Similar
they have also
situated.
received the eviction notices, I think.
Yes, similar.
So in that case, if you want that similar kind of order should be there,
My lord.
then I should suggest
May
that maybe
lordship,
tagged
yes,
along with
as it please, your honor, my lord, in this case, In the meantime, status quo maybe for the time being that it is.
No, I'm not in a position to pass any kind of that.
Yes, my lord. CRP 15. It may be a serial number, maybe 15760. 15.
It may be a filing number.
Filing serial number. It may be. Here it is mentioned in the cause list.
It's not yet registered.
Filing number.
Delay condemnation is there.
No, I
Yes,
don't know. It
Filing
is not
serial
yet
number is there.
registered.
Can it be mentioned that the filing serial number?
No, that is not. That
IA in filing serial number, that is 15760.
Proceed, because probably it is due to, that is their condemnation of delay.
Yes.
If it is granted, definitely the number
will
will
be
be
numbered.
by the registry of this honorable court.
But till that, most probably number is not there.
Not-
Yes,
It's
there-
not
there-
registered.
Yes, yes. That is the
So
reason.
if you think that we'll just simply matter will be listed after that, in that case only I can do.
ma'am.
Otherwise, you're going to submit your
objection.
That can be record.
Yes, Lordship.
So and so corridor ekla corridor. Is submitted by Mr. Das, the learned counsel for the respondent, that they are going to file written objection in all the matters. Stop. Prayer allowed. I black লিখিব হা এটা দুটি black I মানে I in connection to filing number say ISI এনেকে লিখিব 36 তেওঁলোকে objection দিব কাৰণে prayer দিব file objection prayer is allowed let the matter be called in that case in next date you may make a similar prayer, or if your condemnation is already allowed on the next date, then it will be. So if you want any fixed date here, do you want any fixed date here?
Next date it is on second week of January. So
Second week of
January.
there in that
Yes,
case.
yes. In that case,
Second week of
January.
But
There is
second
no
week of
fixed
January
date.
to again it will be
It will
a
be
bit
vacation.
problematic.
It will be vacation.
It will be difficult for us to file also objection because I have to procure the, that is the instructions from ONGC also, Lord.
My lord, may fix a date, and on that date I will pray for taking.
কিমান দিব বিহুৰ পিছত এটা date.
20. January
Again 23rd, 24th, 20
23rd, 24th, 25th, 26th is holiday, Lord.
years or a holiday again.
It may be on 29th of January.
Maybe.
Yes.
20.
Hello.
20.
Thirty-six, 37 same.
Yes, 30, we are letting 34, 35, 36,
No,
and 35.
35.
35, 36, 37, Lordship.
Oh, sorry, 35, 36, 37.
37.
Yes.
Obligation.
May I please, Your Lordship? There is 482 days delay.
482 days. Is anyone appearing here?
In the cost list, the name has been shown. Health Department and the
Yes,
DA.
comment advocate and DA Assam and Standing Council Health is.
I am appearing, Lordship. We'll file an objection to the Lordship.
You're for
The Health Department.
Standing Council Health
Yeah, for 1, 2, and 3, Lordship.
for 1, 2, and
I appear for respondent number 4.
Government, state.
Government Council now.
So how many days delay it was?
482.
486.
82, my lord.
480?
482.
Okay.
480.
But the cause of action arose in the year 1958. I don't know, kindly come to annex.
This is the merits of the case, my lord. So delay may be condoned. I have explained page number 8 in the IA, para 1340, why the delay has occurred. 482 days after the judgment and order passed by the honorable trial.
But otherwise, as per him, the cause of action is of 1958.
So as per my from our opinion, the cause of action in the year 2017, because when during the when the petitioner due to Yes, due to NRC paper submission, at that time he found in an old almirah, the document found in an old almirah that the land belongs to his mother. And from the knowledge, it may be the cause of action from that date matters. Also, the state cannot take the plea adverse possession against its own citizen. Therefore, the limitation of section limitation of 12 years not applicable in the present case.
Okay.
I have grounds.
You are Mr.
A.K. Hanan.
Heard Mr. A.K. Hanan, the learned counsel for the applicant appellate. So heard. Mr. You are Mr.
D. Upaman.
D. Upamanyu, the learned standing counsel head department appearing for the respond number 1, 2, and 3, and Mr.
J. Singh.
JC
Government
appearing
advocate,
for
respond
the
number 4.
state government respondent number 4. This is an application under Section 5 of the Limitation Act for condemnation of delay of 482 days in preparing the regular first appeal against the impugned order dated 4/4/2024, caused by learned civil judge senior division Hailakandi in title suit number 66 of the. It is submitted by the learned counsel for the respondents that they are going to submit in their written objection accordingly pay sometime. Let the matter be accordingly listed. You need how many weeks after Bihu will do? 4 weeks. 4 weeks.
A date may be given, my lord, after 4 weeks.
Ninth of February. List on 9th of February 2026. Enabling the respondents to file the written objection.
My pleasure.
Yes,
This IA,
39, what was the delay?
280 days delay.
280 days.
80 days. Delay has been explained in paragraph 7, 8, 9. It is mainly health issues and financial problems.
Anyway, we have to hear the other side.
Yes.
So
The notice
this
may
time,
be notice may be issued.
yes, it's noted. You are Mr. Laskar?
All is clear.
Hi, Mr. O. Laskar, the learned counsel for the applicant appellant. This is an application under Section 5 of the Limitation Act 1963 for condemnation of delay of 280 days in filing the connected regular second appeal before this court.
First will be.
Huh? Oh, sorry, regular first appeal.
Yes.
Oh,
Alright.
sorry. You have to make it the correction then. Your post title is not correct. Make an amendment in your, correction in post title.
Yes, yes. Sorry.
280 days in preparing the regular first appeal against the judgment.
Judgment.
Post title is repeating earlier. Post title is also silent about the judgment and order.
Judgment dated 39/2024. 39.
It should be here available in the cost title itself, na? It's not here.
This is not.
Against the impugned judgment and decree dated 30/09/2024 passed by learned civil judge senior division Karimganj in Manisut number 12 public 2019. But while passing the order, it is seen that there is a
Some error in the cost.
It is submitted that there needs some corrections in the cost title of the memo of appeal, cost title of for the present interlocutory application as well as the memo of appeal. That was the
This is. This is correct. Memo of appeal is all right.
So in view of this, learned counsel for the applicant appellate is hereby directed to make necessary correction in the memo of post title of the present interlocutory application. Matter may be immediately listed after the necessary corrections.
But Appeals, Your Lordship. Is condemnation of delay received for the first time. 11 days delay in filing appeal, Lordship.
What was the delay, Your
Lordship.
delay is of 11 days?
11 days, Lordship. But received for the first time, Lordship.
This comment side was there that order could have been passed, but it is a private case, private respondent, na?
Lordship.
That is the issue. Let the notice be issued.
Lordship. By user process.
Only usual process you want?
Only user. That will be better, Lord.
You are Mr. R. Sharma.
R. Sharma.
For Mr. R. Sharma, the learned counsel for the applicant appellant. And this is an application under Section 5 of the Limitation Act, duration of delay of 11 days in preferring the appeal against the judgment and award dated 24/09/2025 passed by learned commissioners, employees compensation, Kamrup M at Guwahati in EC case number 03 of the 2007. Issue notice to the respondent through usual process. Let the matter be accordingly listed. You want 4 weeks or 3 weeks? After 4 weeks. As on a date to date by the ministry.
Problem, Lordship.
May I please, Lordship? Lordship, limitation is by 178 days, my lord. It is for the first time, my lord. Let the notice me go, my lord.
I don't know. How many?
178 days, my.
Why we have paid the reasons you have for your official formalities or what?
Official formality, actually, my lord.
Achha, yes. Anyway, we are issuing notice the first time he has come. Pardon, Ms. L. Sharma, the learned counsel for the applicant appellant. Witness him to issue notice for you this time. We are listing it after 4 weeks. Issue notice to the respondents.
Yes. Obviously.
May I please, Your Lordship? Lordship, this is a condemnation for 89 days, Your Lordship.
89 days.
It has
RSM.
listed for the first time, so a notice may be issued, Your Lordship.
Yes. Same order, more or less. Part
A. Biswas.
for Mr. A. Biswal, the learned counsel for the applicant appellant. This is an application under Section 5 of the Limitation Act, seeking condonation of delay of 89 days in preparing the second appeal against the judgment. What is the judgment?
Lordship, against judgment dated 27/5/25, Your Lordship.
Judgment dated 27.
27/5/25 passed by the Court of the Civil Judge Senior Division, Amingao, in title appeal number 32 of 19, Your Lordship.
32 of
19.
19.
Title appeal 32 of 19.
Against the judgment and second appeal question against the judgment and the order dated 27/5/2025 passed by learned civil judge senior division America in title appeal number 32. Issue notice. Here you want to issue notice it through speed post also?
As
Now
Your
it
Lordship pleases.
okay, then speed post and both usual.
Yes,
also. We're listing it after 4 weeks.
Yes, highly obliged.
Kata order.